Can I just say something about Andrea?
Good morning, everybody. Welcome back. We are about half an hour out from court continuing on the defense motion to disqualify the prosecuting attorney in the case against Tyler Robinson. For those of you that were here last time, you know that things got kind of bogged down a little bit going into the motion because they've only set aside an afternoon for these hearings. There was an expectation that evidence was going to be presented, witnesses were going to be called and testified, but there were a number of kind of preliminary things that came up that had to be addressed before they could get into that. And so as a result, they started one witness, the elected prosecutor, Jeff Gray, but they have not yet finished with his direct examination and have not had any cross. And I regret to say that it is entirely possible today may follow the same format, but it may not. We'll just kind of have to see. But there are a couple of things that have come up in the last week or so that relate to this upcoming hearing that I wanted to take a little bit of time to share with you first to kind of give you some context for what to expect and you know, how things could potentially end up getting pulled sideways like they were last time. But it just depends ultimately on how the judge decides he wants to deal with these things. So the first thing that happened is that this one is actually quite interesting, I think, because the defense is letting us know that the state plans to present evidence at this hearing, and the defense does not want some of it to be presented, either because they think it is not admissible, which are these rules here, 401, 402, 403 of the Utah Rules of Evidence. They're basically saying, we don't think this is relevant, and if it is, it's so prejudicial that that outweighs any probative value that the evidence has. And of course, the constant refrain now, everything implicates Mr. Robinson's right to a fair trial under Article 1, Section 12 of the Utah Constitution and the Sixth Amendment to the United States Constitution, which of course I don't mean to trivialize in any respect. These are quite important rights. It's just that the defense has been invoking them in these kind of broad, unspecified types of terms repeatedly. And so my concern here is that the defense might be kind of running the risk of crying wolf a little bit, that when everything is undermining Tyler Robinson's right to a fair trial, you just run the risk then that nothing is, because the time when you have a strong argument, it may potentially be diluted by all the times that you've raised it where it wasn't particularly well-founded. So, of course, this motion in and of itself doesn't tell us a whole lot about what's at issue, but we got a response from the state, and the state's evidence tells us quite a lot more. They want to bring in video recordings of the shooting, and it's not just one, they have several. So this is the particular evidence that's at issue. The one that the defense is objecting to, 4.1, this one right here, video from which Exhibit 4 is taken, which includes the impact of the bullet on Mr. Kirk, as well as blood coming from his neck and him falling from his chair. Now, those of you who had the grave misfortune, as I did, of logging into Twitter on September the 10th, video that certainly fits this description was everywhere. It was kind of hard not to see it. I don't know, maybe some of you have better algorithms than I do, but I was certainly served up this video over and over again. So while I don't know that this is the same one, it's certainly possible, and at the very least, it sounds like the kind of video that is consistent with the one that was kind of out there for everyone to watch. But there's also quite a few other things. Video showing his arrival, video who recorded a person in a shooting position on the Low C Center just moments before the shot. Video that recorded the area behind the booth just before and after the shot, showing the location of other people. This is supporting the state's argument that the aggravating circumstance of the killing potentially endangering other people as well, justifying the death sentence. This is the evidence that they are offering in support of that. So still frames from some of those as well. And then lastly, a video that is from directly behind and above Mr. Kirk, which shows him, members of his security team, the questioner, and the crowd. So just a few items that they want to introduce at this particular hearing. And their argument for it is basically, look, if the defense wants to litigate whether the prosecutor's daughter, who was present at this scene, present at this incident, is a material witness, then we will litigate it. That's what you want. Then we will show what was there to be seen. We will show who was able to see it. We will show, from this, how we were able to determine kind of where the pertinent events took place, where the pertinent people were located, and therefore why the prosecution has concluded, she wasn't in a position to be able to see anything anyway. And, ultimately there were hundreds, if not thousands, of other people that are in a position to be able to see that. So that is the argument for the relevance. To me, I think it's going to meet the standard. It is relevant. That's the trade-off when you put disputes at issue. Then the party gets a chance to prove the relevant circumstances to be able to make the legal ruling. So I think it is relevant. Is it more probative than prejudicial than probative? Not in and of itself, but the issue that the defense is kind of highlighting is the potential for this evidence to then become publicly available. It is highly unlikely this would be live streamed. If they do admit it at this hearing and play it, it just doesn't. It's pretty routine that the graphic stuff doesn't get restreamed, but don't know. There's nothing in the current order that says whether or not there's a restriction on televising any particularly graphic content. But at a bare minimum, if this is admitted as an exhibit, then it is presumptively a public record because it's a court record. It is something that the court is being offered to rely on for purposes of decision making. So that implicates kind of First Amendment and common law rights of access beyond just Utah rules. So the defense doesn't want this public, and that's really their primary argument for it being them not wanting it admitted into evidence. Now, I do find it interesting that I don't know why they limited it to 4.1, which seems to be the one, like I said, kind of fits the description of the one that has already been out there and millions of people have already seen. And so the idea that this one is the one to focus on is potentially prejudicial, as opposed to these other ones, which, not necessarily quite clear that these have received the type of, public distribution that 4.1 got. All remains a bit unclear to me. So first thing we're going to have to deal with is essentially this objection and how it's dealt with. It's possible that they're going to want to argue this ahead of time so that everybody is, I guess, on the same page about how the questioning is going to transpire. But it's also possible that the judge is just going to say, wait until it's offered, because that is also, kind of common as well. The judge doesn't want to take up time considering objections and arguments and things like that about issues that are could be hypothetical. And so if, the state maybe doesn't offer it, then it never comes up. And if you've spent half an hour at the beginning of your hearing talking about it, then you've, wasted a whole bunch of time. So possible they would just defer it until the point at which the exhibit is introduced or offered into evidence. So we'll see. We'll see how that goes. We'll see how that goes. But possibility of some additional evidence there getting into the public record. And one of the reasons why I guess I find this particularly interesting at this point of the process is just because there seems to have been a lot of confusion and just misinterpretation about the process and the state of the investigation. And I just see comments from time to time suggesting that the state's evidence is limited to what was described in the probable cause affidavit. And so this is a really clear example of why that is not the case. This is like the first time that I can think of anyway that we're hearing of new specific pieces of evidence that were not specifically described in the probable cause affidavit. And yet, of course, the state has them. They're telling us they have them. And so it just goes to show that the investigation did not stop with the arrest of Tyler Robinson. And in many respects, it would have just begun with the arrest of Tyler Robinson. And so we can and should expect that there is a significant amount of information and evidence that has not yet been described to us. This is what I am particularly looking forward to the preliminary hearing in May to see what else they have been developed. Just some things off the top of my head that I know they would have looked at, but we didn't hear anything about, would be things like his digital footprints. Of course, they would have done a search warrant, executed a search warrant on his house. They would have taken his devices. They would have done forensic examination of everything that he has. From that, they would have parsed communications. They would have looked through finances. They would have looked for location data to be able to track his footsteps and things like that. So just the potential for a very large volume of evidence there to have been recovered that because of the timing of Tyler Robinson being arrested, pretty contemporaneously with him coming to the attention of law enforcement at all, is the type of stuff that is only going to be developed after the fact of him being taken into custody. So then the next thing we have that this may take up a lot of time or it may not. It's just going to be, again, a little bit of a wait and see how this goes. But the defense is renewing the request that they made at the beginning of the last hearing, where they say the Utah Attorney General needs to be handling this motion to disqualify, that it's like improper for the Utah County Attorney to be handling the motion when they themselves are, under question, under accusation, I guess, by the defense as having a potential disqualifiable conflict. And Judge Graf at the last hearing basically said that he doesn't think that the defense has met a threshold to show that there is a likely, perhaps probable, conflict of interest that would disqualify the prosecuting attorney's office in this case. And then without that, he doesn't really see a justification for requiring the attorney general to get involved. The idea is kind of putting the cart before the horse, that you are assuming there's a problem for purposes of not allowing the prosecutor to continue with the motion, but we don't know yet if there is a problem. And so he seems disinclined, shall I say, to go along with this particular request. So they filed this memorandum of points and authorities, and it's just essentially setting out some legal issue, but then they're getting combative. The defense is getting combative kind of with everything. This is starting to become a bit of a theme in the pleadings. They are accusing Mr. Gray of an ad hominem attack on Mr. Robinson and his counsel, to the effect that the request for referral is another stalling tactic to delay these proceedings. Now, this is not an ad hominem. Like, an ad hominem is like, you're dumb, therefore we don't have to listen to you. It's accusing the person who is making the argument of some kind of, personal failing or just an insult or whatever, means that they lack authority to offer this kind of position. And I don't see that this qualifies. This is the prosecutor characterizing his interpretation of the defense strategy. And it's not generous. It certainly isn't generous, but it's not illegitimate. They're entitled to kind of have their interpretation of what the defense is doing and argue that to the court, because the court is appropriately, should be concerned about the legitimacy of the requests that are being presented to it. So this is just a little bit of a sign of attack. We're seeing this in other pleadings, particularly involving the courtroom transparency. The defense has really gone on a just big attack against the media, and lots of suggestions of impropriety for doing, just for a variety of things, which is what makes it a little bit odd. They're blaming the media for things that, for example, secondary content producers, people who like watch the court stream and say things about it, hello, like us, blaming the media for things that other people are doing with the information that the media generates. But then also challenging just normal news gathering, things like the media, how dare they? They're using information that they get from the court process and trying to interview people about it. Like, yes, this is what the media does. And so it's just notable to me to see that the heat is being turned up a little bit, primarily from the defense. I'm not seeing a lot of shots, coming back the other way. At least not in such aggressive terms. So anyway, that was a little bit of a side, but just a thing that we have, at least I have started to notice with the recent filings. So this is their memorandum, and at the end of the day, when I read through it, I'm not going to read through it the whole thing here, but it doesn't really add anything new to what the court already considered at the last hearing. I'll share with you, this is the statute that they are relying on for this argument that the prosecuting attorney needs to get out and bring on the AG. And it's this one right here. It's a subsection 2. The attorney general shall assist the attorney with a criminal prosecution if a court finds that the attorney is unable to satisfactorily and adequately perform the duties of prosecuting a criminal case and recommends that the attorney seek additional legal assistance. So the statute that they're relying on is kind of predicated on the court making this preliminary sort of finding that because of the conflict, the prosecutor can't satisfactorily and adequately perform the duties of prosecuting the case, or at least the motion in this particular context. So they've already kind of fleshed that out, because Judge Graf said, I don't think what you've established here rises to the level of a disqualifiable conflict. I'm going to let you have your hearing anyway to take your evidence and see what type of record develops, because that may change. But for purposes of going through the hearing itself, there is not an initial showing that they are unable to go forward the way that prosecutors are required to do in light of this relationship. So I don't think any of that will change. The state did, of course, file a response, and they just, a couple of points. They say, first off, that statute doesn't even authorize what they're suggesting needs to be done. They are saying that, kind of reiterating the findings that the court kind of already made, that like, and I don't think we're here. I don't think we have the standard of a conflict of interest established, at this point prior to the evidence being taken. But also they bring up a couple of different issues. They're arguing it's untimely. This came up last time too, where they're like, look, you kind of sprung this upon us without briefing and stuff. Well, now they provided the briefing, but only just a couple days before the hearing. So I doubt that Judge Graf is going to, decline to deal with it solely on the grounds that this is kind of late. Because he hasn't given me at all the impression of a form over substance kind of guy. If it's an important issue, he's going to want to deal with it. But it's not entirely clear to me. Like, this is reading, from my perspective, a lot more like a motion to reconsider what he already did. And so I think he would be well within his discretion if he wanted to just basically treat it like that and say, we already fleshed this out with argument at the last hearing. I've reviewed the motions. There is nothing here that changes, legally or factually, the reason why I denied this last time. So we don't need to deal with it any further. I think he would be well within his rights to do that. And that would certainly be the efficient way to go forward and handle it. But we'll see. He does also seem to be quite patient and want to give the parties every opportunity to be able to fully argue their positions and make their records and so forth. So it is possible that we could start off yet again dealing with this because if he were to change his mind and the Attorney General needs to be involved, then you want to decide that now before you've gone down the road, continuing with the hearing and so forth. The only other thing that's kind of new that the prosecution brings up here is they bring up separation of powers principles, which we kind of talked about a little bit last time. The idea that the prosecutor is the elected official, and he's the one with the constitutional authority to conduct the criminal prosecution for this area. And so for a judge, a member of a separate branch of government, to interfere with the voters' choice of prosecutor representative, it does implicate separation of powers. And so that's why they have to have a pretty good reason to do that, either based on conflict types of principles, or some other type of statutory authorization that would allow them to step in. That's like a limitation on what the prosecutor is allowed to do that needs to be enforced by the judge. So these are considerations that have to be balanced a little bit carefully. And so the prosecutor is leaning heavily into those as well. So we'll see. We'll see how far they go with that. Now, this one that came up is definitely going to affect today's hearing, because we already know they are going to renew their request to close certain parts of the evidence. The judge at the last hearing refused a blanket closure, even though literally everybody, even the media lawyer was up there saying, we agree, it's totally fine, there's privacy interests and stuff like that. Go ahead and close the courtroom for this evidentiary hearing. The judge said, not going to do it. There's too much at stake with the public interest and the public's right to know what is going on and the basis of the decisions being made. So I will consider on a witness by witness type of basis whether we're going to close the courtroom. So this is in response to that. They are going to renew their request to close the courtroom for the testimony of Prosecutor A and the adult child. This is something that the defense counsel agrees with. We'll have to see what the media says about it. But ultimately, their goal is to protect the personal privacy and safety of these two individuals. They don't want them identified. They don't want people knowing who they are and potentially going after them. And here's their proffer. Okay, their proffer is based on some allegations of harassment that so far have affected everybody in the case. But they are dealing specifically with Prosecutor A, received threats for his work as recently as 2005 in a different case, not this one, A defendant made efforts to collect personal information, including social security numbers and property tiles of Prosecutor A, law enforcement, and their family members to disseminate on the dark web. And in letters, the defendant specifically mentioned the prosecutor by name, as well as his family members by name, calling the prosecutor his number one priority target. He communicated what he believed was the prosecutor's address and phone number to an acquaintance, instructing that acquaintance to work with others to use this information to target Prosecutor A by placing liens on his property, publishing personal information on the dark web, and engage in spoofing and phishing scams against him. So this is this is some not real good stuff. You have to deal with people doing frivolous stuff with your property rights, trying to get people to come in and hack you and stuff like that. Not real pleasant to be subjected to. In one letter, after listing Prosecutor A's name and purported family members' names, the defendant in that case stated, "We need to have maximum exposure on Prosecutor A." He continued, "We need to prepare all UCC-1 filings, which are the liens on the property, against these pieces of shit. Also, comb social media and get on reaching out to Tyler Robinson's supporters online and post this letter containing the names and family members' names and address and phone number." The defendant in that case also wrote, "Please go on a DW forum to expose this intel to all who believe in Tyler Robinson's setup and innocence, and post this letter to forum group chats about Prosecutor A." In another letter, the defendant in that case wrote to his contact, "Can you forward this for me to the DW?" And then he listed Prosecutor A's name, his family members' purported names, his purported address, and purported cell phone number. So we got a guy in another case, seems to have some fairly antisocial tendencies, who is trying to solicit assistance with prosecuting, with harassing this prosecutor from people who believe in Tyler Robinson's innocence. That's a little concerning. That's a little bit concerning. Don't know if any of that has happened, but the idea that people are trying to further their own interests by kind of fomenting this type of activity against the prosecutor, kind of alarming. So the defendant in that case has carried out some of his threats by attacking law enforcement officers and causing significant bodily injury to at least one law enforcement officer. So this is more than just trivial and hypothetical. That particular case, guys carrying it out to the point of physical injury. I think pretty much anybody who is under threat is going to be concerned about it. And you're certainly going to be more concerned about it if you know that this has actually been followed up on, like gives some credibility to the nature of the threat. So this particular case has generated great publicity. Some people have threatened retaliation against Mr. Robinson, while others have applauded the killing of Charlie Kirk. There is high emotions on all sides of this case. Many witnesses in the case have received threats because of their involvement. Some have relocated to avoid these threats. Many have deleted online accounts and changed usernames and social media handles. Members of Charlie Kirk's security team have reported threats, doxing, the publication of personal information online for harassment purposes, and risks to them since Charlie Kirk's murder. Defense counsel has hired private security due to the danger this case has caused counsel, and the UCAO has increased its security protocols due to the risks this case has generated. The Utah County Sheriff's Office has increased its security protocols in transport and custody of the defendant during court hearings and as it relates to the security of the courthouse. So just a factual proffer that is stipulated to, this is agreed between the defense and the prosecution. They are agreeing these are facts. We don't have to call in a witness to testify to these specific things. These are facts that the court will be allowed to consider in order to evaluate whether there's a legitimate fear for privacy, for like security that warrants keeping private the identities of Prosecutor A and the adult child. High profile cases are, often going to generate some off, attention. There are plenty of delusional people out there that fixate and things that are, high profile in the media and stuff, just kind of by opportunity. They are there to give people like that sometimes something to fixate on. So some of this is just a little bit of the cost of doing business. It's something that you assume the risk of when you get into this line of work. It's just going to happen. It happens to, as they point out, the defense lawyers are dealing with this too. It is something that I've experienced, people, being threatening over a certain case that you handle or an outcome that you got or something like that. Most of the time, it doesn't go anywhere, but you just never know if there's going to be a situation where it does. And of course, that's the one that you're most concerned about. So I can certainly understand the concerns about it. The prosecutor, in my view, I think assumes a certain amount of risk of that, as does the defense attorney. But I'm not sure about the prosecutor's family. I'm not sure that the prosecutor's family, just by virtue of being born into this family, has necessarily assumed the risk of being, exposed to this type of thing. And I would expect the judge is likely to be sympathetic to that. So ever since the last hearing, I kind of expected there's a pretty good chance that the child is going to be, we say child, but of course it's an adult, but I don't want to say offspring, because then all I can think about is how none of these guys are very fly for a white guy. Okay. not gonna say offspring. I suspect that the judge is going to be sympathetic to the child, and that's why, I feel like he telegraphed pretty clearly from the outset that, bring it to me on a case-by-case basis, because it means he's willing to consider it, not for everybody, but for some. I think there's a pretty good chance that the child, the witness, is going to be allowed to testify in closed session. With the prosecutor, a little bit more of an open question, and I think it may just come down to, with the prosecutor testifying, jeopardize the confidentiality of the adult child. We know enough about it that if we know who the prosecutor is, probably going to be able to identify who that person is. And of course, I know that there has been some leaked information, filing that was the prosecutor's initial filing that ultimately was redacted in public form. It was inadvertently put on the court's, the website to get the court documents in the unredacted form, and some folks did obtain that. So there is already, it's kind of out of the bag in some areas, but it has not been widely published. It hasn't been in the mainstream sources or anything like that. So it's really just about, I think, limiting the potential damage that could come from if the prosecutor's identity becomes known. Is that going to give away the child's identity, who I think is who the court is most likely to be concerned about? I'm just checking repeatedly on our stream status here. Of course, they are not allowed to go live anymore until court is being called into session, so that they don't just sit and stare at the defense counsel table and get terrible lip readings and so forth. So it is probably going to come on, quickly and catch me by surprise. But just monitoring that to make sure we don't miss it. So the last thing that was just filed recently that was a bit interesting was this notice here from Erika Kirk. Now, this is not going to particularly affect anything today. We already know the cameras are going to be in here today. There's just going to be potentially issues about closing off particular witness testimony that this would affect. But essentially what this is Erika Kirk has filed a notice pursuant to her rights to be heard as the victim representative in the case. The Utah victims' rights law, like many states, gives the victim of a crime certain rights vis-a-vis the process. And one of those is a right to be heard on material issues that would affect the victim's interests. And so she is arguing based on this that there needs to be maximum public transparency. She wants to, recognizing that the court has to balance the right to a fair trial with the public's First Amendment right of access. She wants any request by either party to essentially close these court proceedings from the public eye to be denied, because without meaningful access, the public will be unable to directly observe and evaluate the evidence presented, leaving a critical gap in understanding the circumstances surrounding his death. And in the absence of transparency, speculation, misinformation, and conspiracy theories are likely to proliferate, eroding public confidence in the judicial process. Such an outcome serves neither the interests of justice nor those of Ms. Kirk. So this isn't like a motion. This isn't something that the court is going to set a hearing and rule on or anything like that. What it is just her stating her position, putting her position on the record on issues related to courtroom transparency that are kind of repeatedly coming up over and over in the course of the case. We got a number of things that have been filed recently that deal directly with this. We've got a motion that was filed on January 9th that we don't know what it is, but it was filed under seal. And so there's arguments about that motion being under seal. We have the defense filing a motion to remove all of the cameras from the courtroom. They have also filed that motion under seal. And so there's litigation about the motion itself, as well as the process of sealing all of these things. So this is not like a new and separate issue for the court to decide, but it is something to be there as background information as the court is considering all of those different motions that are presented, that this is what she thinks. She wants us to see it all. Erika Kirk wants us to see it all. Okay, things have just gotten started. So let's go ahead.
Before imposing any sanction, the court will make specific findings on the record.
Oh, God.
In addition, the court may consider any remedial measures, including immediate suspension of video transmission for the hearing in which the violation occurs, with proceedings continuing on an audio-only basis, and disqualification, if necessary and narrowly tailored, of the news organization that filed the request in order for electronic media coverage of the court proceedings for that hearing from serving as pool camera operator in this matter, where such a measure is required to ensure compliance with the standing decorum order and protect the rights of the parties. Any such remedial measure would be considered only as a last resort and only to the extent necessary to address the specific violations at issue. Counsel will have an opportunity to provide input before the court makes any final determinations regarding sanctions. The court values that input and will give it careful consideration. I want to be clear that these measures are intended to preserve open and transparent courts while ensuring fairness to all parties, and the court remains fully committed to the presumption of open proceedings under the applicable rules. Rather, these measures exist to protect the constitutional rights of all parties while preserving the integrity, fairness, and orderly conduct of these proceedings. With respect to media coverage in the courtroom, the court offers the following additional guidance to assist everyone in navigating today's proceedings. The pool camera has been relocated to the rear of the courtroom. The camera operator shall not zoom in on any individual seated at counsel table. When counsel tables are filmed, the camera must remain in a wide shot that includes all individuals seated at the table. Attorneys and witnesses may be filmed individually when standing at the lectern or seated in the witness box. I would also ask counsel to be mindful that microphones are located throughout the courtroom and may pick up conversations. Counsel may wish to consider using screen protectors on laptops and taking reasonable steps such as covering one's mouth when speaking to avoid the inadvertent capture of private communications, whether by camera, microphone, or those present in the courtroom. Third, the court wishes to address the camera operator. At this time, Mr. Josh Demick, could you come forward to the lectern?
Gonna do the public shaming again. Sorry about the sound, guys. This is awful, but I don't think there's even another feed.
Could you please state your name and spell it for the record?
Yes, my name is Josh Demick, Josh Demick.
Thank you. My intention is not to cause you any embarrassment or discomfort, although it's probably not feeling that way on your end. I simply want to ensure that the expectations for today's proceedings are clear. During today's hearing, what is your primary role?
My role is to cover the hearing that we have going on this afternoon, and I have read over the Decorum and the EMC as well. My plan is to solely focus on the individuals that will be speaking up here.
All right, you anticipated my next question, which was, have you read the December 23rd, 2025 Standing Decorum Order, which you have, and I appreciate. And do you understand the guidelines as they relate to your responsibilities today, including the additional guidance regarding camera position at counsel table and the filming of attorneys and witnesses that I just put on the record that was not in the Decorum Order?
Yes, Your Honor.
All right. Do you need any additional time to review the order or to reposition the camera to ensure full compliance?
No, Your Honor.
Could you fix the judge's
Do you
mic?
anticipate any difficulty complying with the order or today's guidance?
No.
All right. Thank you, Mr. Demick.
Thank you.
Before I let you go, as I just asked questions of the pool camera operator, Mr. Demick, I'll turn to counsel. Do you wish to weigh in on what the court has just done?
No, Your Honor, thank you.
Thank you.
Yes, thank you, Your Honor. Richard Novak for Mr. Robinson. May I speak from here?
Yes, Mr. Novak.
All right, thank you, Your Honor. We appreciate that the court, on its own accord, moved the videographer. I don't know where the still photographer is, but we continue to be concerned that any video images of Mr. Robinson during court proceedings, close-up images of Mr. Robinson during court proceedings, interfere with his right to a fair trial. I think I heard everything the court said about the videographer, but the still photographer is still seated in the same place where they were last week. And we would ask the court to order the still photographer not to take any photographs of Mr. Robinson's face or person during the hearing, in the same way that the videographer has now been ordered to be focused on the court, the witness, if somebody's testifying, counsel at the lectern, or generally the people seated at counsel, what the court referred to as counsel table. We do not want to see still images again of Mr. Robinson's face in the media with more speculation about meaning of his facial expressions or the lack thereof. And so we really appreciate what the court did on its own, sua sponte, I guess we would say. But we have the same concerns about the still photographer.
All right. And before I address that, any questions as it relates to Mr. Demick? I want to excuse him to go back. Standing in front of the court is no fun. And I recognize that.
I was just trying to keep him up there as long as possible.
I see. All right. Mr. Demick, thank you so much.
Thank you very much.
All right. Before I address that, I'll allow the parties to be heard before I address what Mr. Novak has brought up as it relates to the still photographer. To the state.
Your Honor, I think Your Honor is appropriately concerned about the video, any close-ups of Mr. Robinson. I'm not sure that a still camera presents the same concern. This is a public hearing, and I think that that it's appropriate that still photography be taken. I don't know that it raises the same concerns that Your Honors raised with the video.
Thank you. Any other party wish to be heard?
I'll be brief, Your Honor. Michael Judd on behalf of the news media. We agree that with what the state has just said. The concerns that I understand the court trying to address involve the capture of moving lips that can be used by lip readers. We have dealt in the past with inadvertent overhearing of actual conversations. I don't think still cameras present the same issue. The idea that a participant in a public hearing, including the defendant, cannot have their image captured by a still camera because a facial expression is somehow too much to let the public see, we simply don't agree with. It is, of course, the court's prerogative to set the guidelines that it believes are appropriate to balance these interests, but it will come of no surprise to the court that the news media believes that particular measure of saying even a photograph of a defendant in a public courtroom is too much to allow without threatening fair trial rights in a way that goes beyond that balance. We think that's too far.
All right. Mr. Novak, I do have a question for you. Has there been a violation of the Decorum Order by the still photographer in any of these proceedings?
Good question. I don't think so.
I am not aware of violations by the still photographer, but I am very aware, if I may, of what we believe is unfairly prejudicial media content based on the images. And video images, yes, can be embedded in electronic media, but still photographs also are still appearing, still photographs from the courtroom are still appearing in print media.
Of course they are.
And in less, what we've referred to as less formal media channels. So we are still very concerned, and I don't understand why there would be any even marginal negative access to the public to this hearing by the still photographer being in the back of the courtroom and taking photographs of the court, meaning Your Honor, of witnesses on the witness stand, if that's what the court's going to permit, of counsel. I don't have a problem with that. But we continue to have grave concerns of huge photographic lenses being focused on our client. And the results of that, and I'll just make a representation to the court that while we were in court last time, Mr. Burt and I both received, literally in real time, long ranting voicemails from people who were watching the proceedings. Now that was on video. I received another one of those calls today referring to my client's facial expressions from somebody who decided to leave a long, aggressive message on my office phone. And I'm very concerned that even still images of Mr. Robinson's visage in the courtroom are going to interfere with his right to a fair trial. And we've reached the point, because of the prior violations that have occurred and because of the nature of the media coverage, where Mr. Robinson feels like he may have to make a choice between two of his Sixth Amendment rights. And that's the right to a fair trial and the right to be present. And we want him to be able to have both of those rights and all of his rights. And the way he can exercise both his right to be present and his right to a fair trial.
Media, what are you doing?
Camera to where the video camera was ordered to be.
Turn the game
Mr.
down
Novak.
from 50 or
Thank you all
whatever.
parties. I appreciate your input. This is an important matter and the court takes it very seriously. I note that there has been no violations of the December 23rd, 2025 Decorum Order by the still photographer. That being said, this court wishes to exercise caution and will request that the still photographer go behind the bar, to the bar being the separating lower wall, and reposition his camera at that place. I appreciate the patience of all parties as we do this. And again, this court is balancing open and transparent courts with the constitutional rights of all parties involved. All right, while that's occurring, I'll turn to the state. The court would appreciate a brief update on the status of discovery.
Your Honor, Chad Grunander for the state. To date, we have shared with the defense 100% of what we have received from law enforcement. With that said, we have been informed late last week that there is approximately, there's several terabytes of digital evidence from phones and other digital devices that the State Bureau of Investigations has in their possession. We are collecting a 20 terabyte hard drive to two of them, one for us and one for the defense. We did receive a letter, I think this morning, from the defense outlining their expectations with respect to how that would be received, original form, and more specifics as well. So we're in the process of coordinating that download onto those hard drives of the digital evidence that's been collected, and we will provide that as soon as we receive that and it's downloaded to the defense.
What did we say?
We are
Digital.
still working with law enforcement on the download of approximately 30 days of all of the surveillance video at UVU. We were told it was approximately 300 terabytes, and that's being downloaded 24/7. So that is still in process. So we're actively working on that and looking forward to collecting that and passing that along to the defense. It will need to be shared in some sort of similar fashion, I'm sure, with respect to hard drives.
Thank you, Mr. Grunander. And does defense want to be heard?
That is correct, Your Honor. Stacey Visser on behalf of the defense. We are in communication with the state about what we believe is missing at this point, and we are anticipating a large amount of digital discovery in the next few weeks that we will need to process.
All right. Thank you.
May I supplement this conversation, Your Honor?
Briefly.
Thank you, Your Honor. We've kind of divided up discovery responsibilities, and mine is to address what I'll call non-digital forensics. So there are many items of seized evidence that have been sent to various law enforcement labs around the country without getting into the details. We have some what I'll refer to as summary reports of those evaluations. But as the state attorneys know, we're going to need all of the underlying data, notes. These relate to things like DNA and other forensics. So if we haven't provided them with a very, very detailed list of the types of documents we need, we will. But I think Mr. Grunander could speak to this in more detail in terms of the status of that. But I think that's another big chunk of materials that presumably the state attorney's office has not received yet from law enforcement. And so obviously they haven't had a chance to give it to us, and we haven't had an opportunity to look at it or to have our own experts review those types of materials.
Thank you, Mr. Novak. All right, before Mr. Grunander.
We'll make a point to follow up on that with the law enforcement agencies. We'll communicate with defense counsel on that, Judge.
I appreciate the cooperation between the parties. Before the court proceeds further, it's appropriate to address the record. The court notes the recent filing by victim representative Erika Kirk involving the statutory right to a speedy disposition of the charges under Utah Code Section 77-38-7 sub 2. This court raises this issue solely to ensure that the record accurately reflects the statutory obligations governing the matters presently before it, and not to suggest any view regarding the merits or outcome of these proceedings. Under this statute, a crime victim has a right to a speedy disposition of charges free from unwarranted delay when considering a defendant's request to continue a previously scheduled trial or other significant criminal proceeding, the court must inquire into the circumstances asserted as the basis for delay and must consider the victim's interests in timely resolution together with the defendant's constitutional and statutory rights. The court emphasizes that the defendant's rights to due process, to present evidence, and to receive full and impartial consideration of all arguments remain paramount and undiminished. The court's responsibility to balance these interests faithfully and without preference to any party. As previously stated on the record at the September 29th hearing, justice demanded that both of these principles, the rights of the accused and the rights of the victims, be honored without compromise. With that framework established, the court will hear briefly from counsel concerning how you propose proceeding today.
Please do the state first. Don't let Mr. Novak start. We'll be here all
Thank you,
day
Honor.
on this
Richard
part of
Novak,
the forward.
again from Mr. Robinson. We're prepared to continue with Mr. Gray's testimony. We did file what I captioned a renewed request that this court proceed under a particular section of the Utah Code to refer this motion to the Attorney General. So it's obviously up to Your Honor to decide if the court wants to address that renewed request in writing now or at a different time. I do want, whenever it is the court's view that it's timely, to address the issue that the court just brought up, which is how the court, well, what I want to address is how the court will manage the question of whether Mr. Robinson needs more time to prepare for the preliminary hearing. So the court got an update on the status of discovery. The court noted Ms. Kirk's filing, which of course we are all aware of, and we understand her rights as the representative of the victim in this case. There are challenges under Utah law when the defense needs to communicate to the court the details of its diligence in terms of preparation for a hearing, because we're not going to make a public filing of work product. And I'm sure the court understands exactly what I mean.
Yes.
So what I'm saying is the court brought up the filing and the significance of that for future proceedings. We're going to need to have, if I may, what I would call sort of a case management conference at some point about how the court will manage our need to be able to share with the court the status of our work, which we believe is confidential and privileged, in light of the fact that every time we file something and ask the court to designate it as private, we have counsel for the media trying to unseal it. And we also don't intend to disclose to the state the status of our diligence. And so I'm not asking the court to address it now. I guess I'm just trying to put a Post-it note on somebody's list. It's certainly on our list. And we didn't really intend to bring that up at the outset of today's proceeding. But since the court mentioned Ms. Kirk's filing, it just seems like the right time to mention that. So we're prepared to proceed with further testimony from Mr. Gray and keep going with the evidentiary hearing unless the court wants to address what I captioned our renewed request.
Thank you, Mr. Novak.
Thank you.
To the state.
And Your Honor, the state's prepared to go forward with the evidentiary hearing. We are prepared also to address this renewed request. If Your Honor would like to do that at the outset, I would suggest that Your Honor set a time limit on that argument so that if, assuming that motion's denied, that we can move on with the evidentiary hearing. We've got witnesses who've been subpoenaed. They're ready to testify.
All right. Well, I appreciate that update. And I do want to give some guidance of how today's hearing is going to go. And both parties have touched upon that. based on the record before the court as it relates to the evidentiary hearing, and in order to ensure a fair, orderly, and efficient proceeding, the court will proceed as follows. First, we will address what Mr. Novak just brought up in regards to the referral to the Attorney General's office briefly, and you'll see why I say briefly with my next statement. Counsel will have until 4:30 to present evidence, including cross-examination and any redirect. Motions for supplemental briefing are denied at this time, as the court finds the issues adequately framed for today's proceedings. These parameters are not intended to limit any party's substantive rights, but to keep the proceedings focused and free from any unnecessary delay. Upon the close of the evidence, the court will proceed to argument. Each side will be allotted 15 minutes. Mr. Novak, or to any of the attorneys who would be making closing arguments, if you intend to reserve time for rebuttal, please allocate your time accordingly. This court will conclude at 5 o'clock. And in addition, the court anticipates issuing its ruling via WebEx in order to give the evidence and the arguments presented today the careful and deliberate consideration they warrant. That proceeding will be scheduled at the conclusion of today's hearing. And so, counsel, with that in mind, we will turn to the motion to refer or the motion concerning the Attorney General's office. I will hear from both parties. It is your time. I am not putting constraints on who you call, what questions you ask in part, but keep in mind these time constraints as we address this issue. Mr. Novak.
Thank you, Judge. Keep a leash on it.
Thank you, Your Honor. We filed what we captioned the renewed request, because obviously at the last hearing, we brought the request verbally. And obviously the court's read our renewed request and our points and authorities. We received the brief written by Mr. Ballard, which is very clear and very well written, and we understood the views expressed there. We just disagree fundamentally on what that code section means. We disagree fundamentally on the suggestion that there's a separation of powers problem. It is ultimately this court's responsibility to ensure that parties are represented by conflict-free counsel. Obviously, in the legal profession, there is an initial expectation that counsel will avoid conflicts. But there are always situations where a party needs to bring a conflict on the other side to the court's attention, and the court has both the statutory authority and the inherent authority under the common law to do something about it. So we do believe that this is well within the court's discretion. The statute actually tells the court that it needs to encourage the state to seek assistance. That seems to be a gentle way to say that the state is at least disqualified from litigating its own disqualification issue. And then I'm going to reserve the rest of my time for our evidentiary hearing and closing arguments.
Thank you, Mr. Novak.
Thank you.
Well
Turning
done,
to the
Mr.
state.
Novak.
Mr. Ballard.
Added nothing new. Same stuff we heard last
Your
time.
Honor, it feels like Groundhog Day. Here we are, we've got, again, we're supposed to be having an evidentiary hearing, and Mr. Gray should be on the stand, and instead we're arguing again this issue about whether this court can refer this issue to the Attorney General's office. And I guess if I were in Your Honor's position, I'd be wondering why the defense insists on raising this issue in a way that doesn't allow this court or the parties to be able to fully analyze it and brief it. The defense finally did file a written motion, but waited until Friday afternoon to file that. So as we've outlined in our alternative point in our response, I think this court would be well within its discretion to just deny that motion as untimely. But on the merits of that motion, I think as we've explained in our response, and Your Honor's indicated that you've read that, I think we've explained clearly why this statute does not apply in the way that the defense claims it does. And I'm happy to walk through the statute and the points that we've made. I don't want to belabor that. If Your Honor has any questions about the statute, I'm happy to answer those. But I think it's clear that this statute does not allow the court to replace a prosecutor. At best, what it allows is the court to recommend that the county attorney seek the help of the Attorney General's office. So I don't believe that this statute has any application. The cases that the defense has cited are irrelevant to this issue. And for those reasons, unless the court has any further questions about the state's opposition, I'd submit it.
Thank you, Mr. Ballard. Anything further from the parties before this court issues a ruling?
No, thank you.
All right. So before this court's defendant's renewed request to refer the pending motion to disqualify to the office of the Utah Attorney General. In support of that request, the defendant relies upon Utah Code Section 17-18A-304, which provides that the Attorney General shall assist a county prosecutor only if the court finds that the prosecutor is unable to satisfactorily and adequately perform the duties of prosecution, and recommends that the prosecutor seek additional legal assistance. The defendant argues that where there exists a non-frivolous basis, factual basis, suggesting a potential conflict of interest, the court should make such a finding and recommend assistance from the Attorney General. The court has carefully considered that argument and reviewed the briefings. However, the statute does not adopt the standard proposed by the defendant, nor does such a standard appear in existing case law or court rules. The statute requires specific findings regarding a prosecutor's inability to satisfactorily and adequately perform prosecutorial duties before referral is appropriate. At this stage of the proceeding, the court is not persuaded by those statutory conditions have been met. Based on the record presently before the court, there is no indication that the Utah County Attorney's Office lacks the resources, knowledge, or ability to litigate the motion to disqualify on behalf of the state. Accordingly, the court cannot make findings required under Section 17-18A-304 to justify referral to the Attorney General's office. For these reasons, and without expressing any views on ultimate merits of the motion to disqualify itself, the defendant's renewed request for referral is respectfully denied. All right, counsel, let's go ahead and proceed. Mr. Ballard.
Thank you, Your Honor. Could I just clean up one piece of the record? Your Honor referred to the statute as 17-18A, but I think it's actually been renumbered. It's 17-68-304 is the current citation.
Agreed.
Thank you. I appreciate that correction, and that is correct. I appreciate that, and to clarify the record, thank you to both parties. And so my ruling reflects that 17-68A-304. All right, counsel, are we ready to proceed with continuation of the direct examination of Mr. Gray?
Yes, except to quickly implement the exclusionary order that the court entered at the last hearing with respect to prospective witnesses.
All right, the court will take a very brief 3-minute break in order to accomplish all parties speaking with whoever needs to be spoken to and for them to be excluded, and then we will proceed. It is now 1:38. We'll come back at 1:41. Court is in brief recess.
I'm going to mute it. Of course, they have to pause. I hope, can somebody please come fix the mic during the 3-minute break? That would really be fantastic. They have the gain turned up to 11 or something. It's quite awful. I've seen, some checking other streams to see if there's a better sound, and it seems like it is bad everywhere, which makes sense because it's coming from the pool feed. Well, this process is really starting to turn into a well-oiled machine so far. I'm very happy with it. I continue to grow in my fandom of Judge Graf because I like how systematic he is and how organized he is. He comes in with this clear game plan about how we're going to proceed. We're going to address the motion briefly because you're going to have until 4:30 to present evidence, and then you're not going to do any supplemental briefing. You're going to argue each side 15 minutes. We are going to be done by 5 o'clock, and then we're going to set a future hearing for the ruling that will be done over WebEx. I suspect there may be other hearings that are going to need to be scheduled at the end of the day today as well, just because of the number of outstanding motions. At least one of them has a request for hearing, and that is the media's motion to get access to the sealed filings on an attorney eyes only basis. They're basically arguing that every time the parties file something under seal, the Utah rules require this closure hearing, and the media gets a right to participate in that, but they aren't able to meaningfully participate in whether things should be sealed or not sealed if they don't know what we're talking about. And so they have suggested this process where they will be provided copies of the sealed filings, but they will be under strict orders that nobody but the attorneys are able to look at that. And so that is a process that happens from time to time in different contexts. It's somewhat common in federal court to handle things like this, particularly with discovery, certain types of sensitive discovery materials, confidential materials, materials that relate to, certain types of crimes and stuff like that. So it's not completely out there, and it also does seem to be consistent with the way that the court has handled that type of thing in the past, like when they had the closure hearing about the transcript and what needed to be redacted from the transcript. They all went back into chambers, and media attorney was allowed to participate in that. So seems likely that at least some kind of accommodation is going to be given along those lines. But the media attorneys did request a hearing on that. So that presumably needs to be scheduled. It sounds like the defense is gearing up to request a continuance of the preliminary hearing, doesn't it? We heard some comments there about how are we going to present to you information that shows our diligence in preparing when we need to ask for more time. And this is legitimate. Their preparations are confidential. They don't need to disclose. We've called these experts and we've taken these steps to try to, follow up and review the state's case and develop evidence. And here's who we need to talk to and so forth. So completely understandable that type of thing, there needs to be some mechanism for them to be able to present that off the record. I don't know about Utah rules, but this is commonly handled in situations where courts are involved in providing expert funding and stuff like that. You just handle it ex parte, and it's understood that because these things are confidential, the defense can present their filing to the court, but it is on an ex parte basis. It doesn't go to the other side. Now I can kind of understand his concern about if we file something, it gets under seal under the Utah rules, and then that automatically is triggering interest by the media in getting it unsealed. And of course, like we just said, there's this pending motion for the media's attorneys to be able to see everything that's under seal. And so they don't have any more right to see, his work product, the defense work product, than the prosecution does. So they're going to need to set up some kind of process for these issues to be litigated. Why are they bringing this up? Crystal clear, because he's going to ask to continue the preliminary hearing. Why? Because there's going to be a massive dump of digital data. A massive dump of digital data. 30 terabytes, 20 terabytes. 20 terabytes just of his devices, okay? His phone, his laptop, his desktop, whatever types of computers that he has. Potential electronics in the car and stuff like that. 20 terabytes of that. And then still working on getting 30 days of all of the video surveillance at UVU. That's going to be a massive amount of information. Video files are huge data files. That's why it's 300 terabytes. I don't even know how many cameras it's going to be, but 30 days of everything from all cameras. Yeah, that's going to be a massive massive amount of data. So going to take forever just to download it, let alone to then get it copied and handed over. And then the defense is going to want to review it and so forth. Why? Because they're going to want to go over all of that video footage with a fine tooth comb so that they can look at anybody and everybody. Did anybody go on the Losi Center roof, for example, in the 30 days leading up to this shooting? That's going to be something they're going to want to focus on and highlight and see if that is consistent with Tyler Robinson or not. This particular bunch of data corresponding is going to be potentially significant as well because, and they're back.
That's completely...
Okay, well, I'll represent to you that it was 5 days after the hearing on January 21st. Does that refresh your recollection at all?
Oh, are you talking about after the hearing? I'm aware of that, yes.
Okay, and
Yes.
how did that come to be? Because you testified that your office has no involvement in the investigation.
Well, it was a point that you had pointed out, and so out of an abundance of caution, I believe it was Mr. McBride that decided to go ahead and do that.
Okay, and have the adult child be interviewed.
Yes.
So it's your understanding that Mr. McBride advised SBI to do that interview?
That's my understanding.
Understood. Okay. You also testified on January 16th that you weren't really sure whether your office had a written policy for how to deal with either actual conflicts of interest or the appearance of conflicts of interest.
Yeah, I assume that they did, but I couldn't point to one at that time.
Okay. And then after the hearing, did you locate a written policy?
I did.
Okay. And at the time that you were discussing with the prosecutor whose adult child we're talking about, the fact that that child had been at UVU on September 10th and had witnessed many of the events surrounding Mr. Kirk's death, did you actually consult that written policy back in October?
No, but I followed it.
Had you previously read it?
I'm sure I had at some point. I mean, it's a pretty standard policy. If there's a conflict within the office, then, or a potential conflict, then the attorney will notify us, we'll review it and decide whether any action is needed, if at all.
Okay, but when I asked,
that's what we did.
when I asked you on January 16th, is there a written policy? Your answer was, I'm not sure.
Right.
There was a subpoena for documents that you received and complied with over the last week or so, correct?
Yes.
Okay. And one of the things that we asked for in that subpoena was any memoranda or writings that memorialized how your office handled the potential conflict of interest.
As I understood the subpoena, it's any discussions regarding whether or not there is a conflict.
Right.
And so, yeah.
And so what I take from the return on the subpoena, if I could call it that, is that there isn't any memo to the file. There's no legal analysis. There's no memorialization of the decision that you made that there's neither an actual conflict or an appearance of a conflict.
No, there's not.
A little more disciplined this time. Wanted to spit
You
something else out
mentioned
there.
when you were testifying at the last hearing that you are the president-elect of SWAP. Could you just remind the court what SWAP is?
SWAP is a statewide association of public prosecutors or public attorneys and prosecutors. It's basically a lobbying group with respect to legislative matters that affect prosecution.
And how long have you been a member of SWAP?
for about
As long as you can remember.
the 3 years that I've been county attorney. I've been a member, a board member of SWAP.
Okay. And are you familiar with a document that they produced called Utah Prosecutors Best Practices?
I know that they have that document, yes.
Did you consult that document with respect to what your office should do in connection with the potential conflict of interest or the appearance of a conflict of interest that we're discussing?
I don't believe I consulted it. I relied on my 25 years of knowledge of conflicts and so forth.
Your Honor, what I would like to do, if I may, is approach Mr. Gray with a document that I'm just going to mark for identification as Exhibit I, and that's because we've previously marked for identification A through H, if I have my alphabet correct.
Yes.
And if I may pass one up to the court, I will, if the court needs that.
No, feel free to approach Mr. Gray and present
All right,
Exhibit
thank
I.
you. Gray, I'm handing you something that's been marked as Exhibit I for identification only. Oh, I'm sorry, of course. Have you seen this document before?
I've seen it, yes.
All right.
I mean, there's a lot more than just conflict in our best practices.
Absolutely, but we're just
Yeah.
going to talk about that, okay?
Yeah.
All right, so what I'd like to do is turn your attention to page 2 of that document, which has a whole section addressing conflicts of interest. Would you agree with me that it starts in the middle of page 2?
Yes.
All right. And you see what I'll refer to as General Standard 1.30 conflict avoidance.
Yes.
All right. Could you just read that aloud for the record, please?
A prosecutor should not hold an interest or engage in activities that conflict, have a significant potential to conflict, or are likely to create a reasonable appearance of conflict with the duties and responsibilities of the prosecutor's office.
All right. What do you take to mean the reasonable appearance of
anodyne.
conflict?
There has to be a real actual conflict, that there could be actually an appearance of that conflict.
And that would be in the views of the public, right?
That would be based on Supreme Court case law and case law generally.
But it's an appearance. What I'm asking you is, would you agree with me that there's an appearance to the public?
The reasonable
Objection is
public.
cause for a legal conclusion, Your Honor.
Witness,
Mr. Novak.
well, the witness testified that he's been aware of conflict principles for 25 years. So I think he should respond to that question.
I think this is a good argument to have with the court after the evidence has been presented, whether or not there's an appearance of a conflict, what that means. But I don't think the witness's opinion about it is evidence.
Thank you. I'm going to sustain the objection. Mr. Novak.
Understood. Mr. Gray, why don't you turn to page 3, and that would be standard toward the bottom. 1-3.3C. Do you see that?
Yes.
Okay, could you read 1-3.3C aloud for the record?
If a prosecutor believes that public perception of the integrity of the prosecutor's office and public confidence in the handling of the case would negatively be impacted by a potential or alleged conflict of interest, the prosecutor should consider recusal.
I brought that up because no, unless the legal conclusion is relevant to the fact issue, the court has to decide he can't. But whether there's a conflict or not, what are
All right,
we?
Mr. Gray, I want to ask you some questions about
Is up to the judge.
the decision to file a notice of intent to seek the death penalty against Mr. Robinson and the fact, which is beyond dispute, that a adult child of a member of the prosecution team was present at the shooting of Mr. Kirk, all right? You state in your opposition, well, let me back up. You testified on January 16th that you are the one who drafted the opposition to the motion to disqualify, correct?
Yes.
All right. So even though there's no affidavit by you, you stand by the contents?
Yeah, I said to the extent that we could either proffer that information or testify, and here I am.
Okay. So my first question is there a formal written policy or guidelines or procedure, I don't want you to get hung up on my nouns, for when your office decides to seek or not seek the death penalty in a case?
Anytime that it's an aggravated murder case, there's a potential for that.
Okay, so I understand that because that's what the statute says.
That's right.
But my question is there a policy, a procedure, a protocol, something in writing?
No.
Okay, and is it your view that it's your decision alone because you're the elected county attorney?
Yes.
Okay, and in this case, did you discuss that question, whether the state should seek the death penalty, with your team before that decision was made?
Yes.
And did that conversation include the adult prosecutor whose child is the adult student at UVU we're talking about?
No.
Are you saying that prosecutor was specifically excluded?
No, maybe I misunderstood your question.
Okay.
I thought you asked whether or not we discussed her status as a
Let me
witness
back
there.
up, because it was a bad question if you didn't understand it.
Okay.
Those are the rules, right? Okay. So you discussed with your prosecution team whether or not the state would seek the death penalty against
Yes.
whoever the state accused of committing that crime.
Yes.
All right. And
I should back up. I mean, I don't know that we had a discussion before they actually had an arrest. I mean, that was 2 days later, but certainly in between the time that we filed and then we did have a discussion.
okay, so what you're saying, if I'm not trying to put words in your mouth, but just so the record is clear, is that after Mr. Robinson was arrested, your team had a conversation about whether or not it would file a notice of intent to seek the death penalty.
It was rather informal. I don't know that we all got together and said, what are we going to do? I would talk to different members of my team. But I had pretty much made up my decision. And so they knew where I was going.
Did you make up your decision before there was an arrest?
I thought that based on if we had the evidence that, yeah, we would be seeking the death penalty.
And you were already aware at that time that the child of one of your team members was present at that event, right?
Sure.
All right. Now, what you're saying is that and that you discussed that with all of the team members, even if informally?
As far as the death penalty?
Yes.
Yes.
Okay. And you didn't exclude from that
No.
conversation the prosecutor whose child we're talking
No.
about? That prosecutor was included in the conversation
Yes.
about whether to seek the death penalty?
Yes.
All right. And you're aware, because I think you were present, that there were a number of press conferences held by elected state officials both before and after Mr. Robinson's arrest, correct?
Yes.
Okay. The governor, who's a former licensed attorney in Utah, held a press conference on September 10th. Were you present there?
Probably. I was president at two different press conferences.
So there was one on the 10th and one on the 11th.
I know he made other statements as well, so I'm not quite certain. I know that I was at two different press conferences.
So when Governor Cox announced at a press conference that the state was going to seek the death penalty, had you already told Governor Cox that that was your decision?
I believe his statements, the only thing that I can remember of his statements is he said, by the way, or something to that effect, Utah has the death penalty. And so that's the one statement that I'm aware of. I mean, it wasn't exactly a demand for the death penalty, but so, I mean, the death penalty, ultimately, I made my final decision by the time we filed charges, if that's.
Okay, but the question I asked you was, had you discussed with the governor your intentions?
At some point, I did. I told the governor that I intended to seek the death penalty.
And was that before Mr. Robinson was arrested?
I don't recall if it was before or after.
Okay, I'm going to represent to you, and we can file an exhibit on this in a bit, that on September 11th, the governor said at that second press conference, we are working with our attorneys, getting affidavits so we can pursue the death penalty in this case, and that will happen. And you were standing next to him when he said that, right?
I probably was.
Okay. Had you already told him that you've discussed this with your team and this is our decision?
I may have. I remember telling him that I would be seeking the death penalty.
And so that matters.
Did you tell the
because-
governor that the child of one of the members of your office was present at the shooting?
No.
Did you tell anybody else in state government that the child of one of the members of your team was at the rally?
Not that I can recall. It just wasn't part of my thinking.
Okay. Are you aware whether the member of your team told the governor or anybody in state government about that?
I don't know. Certainly not when I was in the room with them that I can recall.
Now I'm going to ask you the same questions about federal officials. Did you inform any federal officials that one of your prosecution team members, a senior member of your office, had a child who was there at the time of the shooting?
No.
Did you tell anybody in federal government or federal law enforcement that you were going to be seeking the death penalty before Mr. Robinson was elected? I'm sorry, before Mr. Robinson was arrested?
I mean, when I talked to the governor, Kash Patel and Dan Bongino were there as well, so they heard my statement that that's what I intended to do.
Okay. And were you aware that before you filed that notice, the President of the United States went on national television and said, I hope he gets the death penalty?
I had heard that he said that, yes.
And that was before you filed the notice?
Yes.
All right. Now, you stated in your briefing that your decision to file the death penalty notice when you did was partly because you ran for elected office 3 years earlier on a commitment to seek the death penalty.
Yes.
So you made a commitment. Sometimes we call that a campaign promise. I'm not trying to make light of it, but that is what we frequently call commitments that we make to the voters, right?
It was a commitment that I would seek the death penalty in all appropriate cases.
It sounds like if there's aggravating circumstances, then he'll pursue it. Is what it sounds like.
And you knew before you filed the notice that the governor thought it was an appropriate case
Yeah.
and the president thought it was an appropriate case.
Yeah.
Did Mr. Patel express his views?
Not that I recall. I mean, he was doing the bidding of the president. So, but I did find it a little
Interesting.
interesting Governor Cox because he plays no part in the decision. So
Did you tell Governor Cox after he made those public statements, this is not your decision, this is my decision?
no,
Was it important to you that the people you selected to be on the team for this prosecution remain on the team? I mean, you handpicked this team, right?
I did handpick this team.
Right. And the person whose child we're talking about is a longstanding, experienced senior member of your office,
Yes.
right?
Yes.
It was important for you that they be part of this case.
I want the best people on my team, and I believe I chose the best people.
May I have a moment?
Of course.
Thank you, Your Honor. We have no further questions for Mr. Gray. And if I may, what he told me is that he, after the examination, I assume that there's some cross-examination, he'll be available to be on call, so we don't need the court to address that with him, but he's going to leave the building, which is fine with us.
Yeah, but I'll be available to come back if needed.
Thank you, Mr. Gary. Thank you, Mr. Novak.
Thank you. And I'd just like the record to reflect that it's 5 minutes after 2 when I've concluded my direct.
I appreciate that.
Did you?
Not yet.
To the
Wants to
state.
suggest he didn't take all the
Mr. McBride.
time. I just thought it was the comment about Kash Patel doing the president's
I'm going
bidding.
to refer to the prosecutor in your office whose child was present at the shooting as Prosecutor A. Do you know who I'm talking about?
Yes,
Have you ever met Prosecutor A's child that was present at that shooting?
not that I could remember. I could have in passing, but not that I can remember.
Did the presence of Prosecutor A's child have any effect on the decisions you've made in this case?
0.
Did that child's presence have any effect on your decision to seek the death penalty?
0.
Why did you choose to seek the death penalty in this case?
Because the evidence that had been gathered supports the aggravated murder charge, and I believe that the death penalty is entirely appropriate in this particular case.
On September 10th, you've testified that you learned that Prosecutor A's child was present at the shooting, correct?
Yes,
Did her presence affect the decisions you made on September 10th at all?
no,
Will you describe how her presence affected your decision-making on that day and in the few days following before you charged?
it had no effect whatsoever. I mean, quite frankly, as I think I testified earlier, I didn't even give it a second thought after I was told about that.
There's been some question about the reason you chose to seek the death penalty at the time you did. Now, the law in Utah allows you to wait to announce the decision to seek the death penalty until after arraignment, correct?
Yes.
Why did you give the notice of intent to seek the death penalty at the time you did rather than waiting?
I had learned from experience in a prior case, in particular, the Michael Jane case, that in a highly publicized case, the longer that you delay that decision, even though, I mean, I may very well make the decision early on, and I have in certain cases, but the more delay, then it just creates all this unnecessary public speculation and everything else. And we actually, in the Michael Jane case, I went to my attorneys and they said, yeah, we usually wait. So I was waiting, but then Channel 2, I believe it was, contacted me and said that they had learned information that we were taking the death penalty off of that case. And so I had to hurry and call them before that, say that's not true. And within a month, I filed the death penalty. But it creates unnecessary angst with families of victims. I knew that this particular case was I mean, talk about publicity. It's even more so in this case than it was in Michael Jane case. And I wanted to shut that out so that we didn't have to deal with that. And so that Erika Kirk didn't have to deal with that uncertainty.
Okay, as you made the decision in this, so that's the reason you made the decision at the time you did.
Yeah.
Right?
Yeah.
To avoid that uncertainty, speculation, and so forth.
Yes.
Was that decision made because Prosecutors A's child was present at the event?
No.
You talked about a campaign promise. When did you run for county attorney and make that campaign commitment to voters that you would seek the death penalty in appropriate cases?
It was,
What year?
it was about 4 years from this very time.
Okay.
So
At that time, did you know Prosecutor A?
I knew of him, but I mean, because I had handled,
Had you met him personally and interacted with him personally? Or
No.
You just knew who he was?
Yeah.
Okay.
I mean, at some point after I won the election, I met with him and others to determine who.
Understood. But at that time, when you were making that campaign commitment, was it because you knew Prosecutor A?
No.
Okay. Was it because Prosecutor A had an adult child?
No.
Okay.
Wasn't adult then.
Decision making. As far as the decision making in this case goes, who makes the ultimate decisions on major decisions in this case?
I do.
Does Prosecutor A, does the buck stop with Prosecutor A?
No.
There's been some evidence that deputy county attorneys in your office went to the command center at Utah Valley University on September 10th and the days after that.
Yes.
Is that a normal process?
Yes. In any homicide case or big case, we'll have attorneys respond to the command post to offer any assistance that may be needed, which may include search warrants or discussions about, the need for certain evidence.
So having attorneys appear at Utah Valley University that day was not unusual?
How many? I mean,
No. My question is having attorneys appear.
yeah, no, not unusual at all.
Do you know which attorneys went?
Yes. I know that I went, Mr. Grunander went, you went, Ryan McBride, and David Sturgill went. And I don't believe any others. Somebody else may have gone there for a short period of time, but I don't recall seeing them there.
Did those attorneys go there because Prosecutor A's child was present?
Not to my knowledge, no.
Aside from charging, have many major decisions, aside from charging and the notice of seeking the death penalty in this case, have many major decisions been made in this case?
I mean, major decisions. No, I mean, what comes to my mind is one major decision was to make sure that defense counsel gets discovery in a timely manner. That was quite frankly foremost on my mind once we filed the case. And I personally directed procedures to be put in place so that there would be no mistake as to what the defense counsel received and what we had. I mean, every time there's a motion, obviously the team is working on it. We work on it together. But I mean, as far as trial strategies or things like that, none of those decisions have been made.
Is it fair to say that aside from charging and the death penalty decision, is it fair to say that the most important decisions are yet to be made in this case?
Yes.
And that includes trial strategy,
Yes.
preliminary hearing strategy,
Yes.
any plea negotiation.
Yes.
Interesting. Plea negotiations haven't really happened yet.
In all the decisions that have been made up to date, has Prosecutor A's child come up in those decisions?
No. Not
I
that
should say
can-
aside from this motion.
Aside from this motion, yeah.
And so aside from this, I'm going to ask that question again to make sure the record is clear. Aside from this motion to disqualify the Utah County Attorney's Office, has Prosecutor A's child come up in any of the decisions made in this case?
No.
Has Prosecutor A's involvement in this as a witness here affected the prosecution in any way in this case, in your opinion and observation?
No.
Do you believe it will affect the prosecution in the future?
No.
Why not?
Because this is somebody that happened to be there. That has, what we're concerned about is the evidence supporting the charges. That's first and foremost. And that has nothing to do with somebody that happened to be there. Quite frankly, completely irrelevant to anything that matters in the case.
Okay. A couple other follow-ups. Earlier, you testified that Prosecutor A received a you were with Prosecutor A when Prosecutor A received a message from his child that Charlie Kirk had been shot.
Yes.
Is that right? And then you testified that Prosecutor A left to go to the scene. Do you know why Prosecutor A left? Was it to go to this scene and help law enforcement or to be with his child?
To assist in any way we can with law enforcement.
Okay. You previously testified that you did not consult the Attorney General's office about whether or not this was a conflict of interest that would require your office to leave the case or to refer the case. Why did you not consult the Attorney General's office?
Because what they would have done is, researched it and then come back. And I've done that for, over 30 years in my practice. I'm capable of doing that.
Researched it where?
Case law and so forth. Again, I do not believe that there's any conflict whatsoever. I made that conclusion. I stand by that. Out of an abundance of caution, we certainly notified counsel out of an abundance of caution. And I think that's the appropriate action to take. Again, I understand what the concern about conflict is whether or not it has any possibility of affecting your decision-making as a prosecutor. And I didn't see how this does in any way.
Okay, if I can have just a moment.
Let the record reflect, you spent 12 minutes.
You said you had some neighbors that had children that attended the event where Mr. Kirk was shot.
I was told that they were there, yeah.
When did you learn that those people were there?
I don't know, a couple weeks after, I believe, after the event.
After the charging decision was made?
Yes.
How closely do you know the children that were there?
Not well at all. Okay. Maybe a hello or something out on occasion, but as far as I know, I'm not even sure that they even live in our ward at all at this point.
Okay. Thank you.
All right. Mr. Novak.
13
No, thank you, Your Honor. I don't have any redirect at this time.
All right. And as previously discussed, may Mr. Gray be excused?
For now, yes.
Thank you. Thank you, Mr. Director.
Thank heavens.
Mr. Novak, your next witness? Or I'm sorry, Ms. Nestor.
Your Honor, at this time we were going to call the adult child, but I believe that that individual's attorney, they're ready? Okay, then they are ready. So we would like to proceed with calling the adult child at this point. I think it would be appropriate to hear whether or not we close the hearing or at least come up with some ground rules about preventing any photography or mentioning of her name, however the court desires to handle it.
Thank you. I'll hear briefly from the parties. I did read the proffer of facts regarding the closure of portions of the evidentiary hearing on the motion to disqualify the Utah County Attorney's Office, and I'll hear any additional argument or statements prior to making a ruling.
Your Honor, Ryan McBride for the state. We do move to close the hearing for the testimony of the adult child. I think the rationale that I explained previously still stands. The rules of judicial administration allow closure for privacy and safety reasons. I believe with the proffer of facts that the defense has accepted here, we have shown that there are privacy and safety reasons that favor closing the hearing. Defense counsel has stipulated to closure of this portion of the hearing. The media in the past has stipulated to closure of the hearing. I think the record is adequate. I think the safety concerns support closure. And absent any questions from the court, I would make that motion now.
Thank you. Anything further from the parties?
No objection, Your Honor.
All right. So the prosecution cited to the media. Did you want to weigh in?
The media does not object to the closure of this portion.
Thank you. The court has reviewed the parties' prior arguments and materials submitted in advance of today's hearing, including the filing entitled Proffer of Facts regarding closure of portions of the evidentiary hearing on the motion to disqualify the Utah County Attorney's Office. The defense has requested that the testimony of certain witnesses, specifically Prosecutor A, an adult child witness, be received in a closed session pursuant to Utah Rule of Judicial Administration 4-202, citing concerns related to personal privacy and safety. The court acknowledges that Rule 4-202 permits limited closure of court proceedings in appropriate circumstances. At the same time, this court is required to consider countervailing interests identified in Rule 4-202, including the public's right to observe the conduct of public business, to understand the operation of government, and maintain confidence in the judicial process. This court must also be mindful of the constitutional rights of Mr. Robinson, as well as the constitutional and statutory rights of Ms. Erika Kirk in her role as victim representative. The purpose of today's evidentiary hearing is limited and specific. The court is asked to consider the defendant's claim that a member of the prosecution team, referred to as deputy county attorney in one of the motions, has a personal conflict of interest, that any such conflict extends to the Utah County Attorney's Office, and that disqualification is therefore required. The court's role at this stage is to receive relevant evidence and to rule based on the record and applicable law without reaching the merits of those claims in advance. The parties have filed public motions outlining the anticipated evidence and testimony related to the motion to disqualify, including the state's opposition, the defense reply and request to take evidence, and the defense original motion. Those filings describe the general subject matter expected to be addressed at today's hearing. If the adult child witness is called to testify, which is the request at this point, the court will consider that testimony as part of the evidentiary record. After careful consideration of the record, the arguments of counsel, and the interests identified in Utah Rule of Judicial Administration 4-202, the court finds that closure of the adult child witness's testimony is not necessary and would not be narrowly tailored under the circumstances presented. The court further finds that the interests of openness and transparency outweigh the asserted grounds for closure as to that testimony, and that the rights of the parties and witnesses can be adequately protected through least restrictive means available to the court. For those reasons, the request of both the state and defense to conduct the adult child witness's testimony in closed session is partially denied. The court acknowledges that Utah Rule of Judicial Administration 4-202 permits limited closure of court proceedings in appropriate circumstances, and also acknowledges the concerns raised regarding the personal privacy and the safety of the adult child witness. This court's responsibility is to balance those concerns with the constitutional rights of the parties and the strong presumption in favor of open and transparent judicial proceedings. Therefore, the court finds that a brief and narrowly tailored procedure is appropriate to address these competing interests. Accordingly, the courtroom will be temporarily closed, and all parties and members of the media will be excluded for the limited purpose of calling the adult child witness to the stand to state identifying information. Once that limited portion of the proceeding is complete, the courtroom will be reopened and members of the public and the media will be permitted to re-enter. During the testimony of the adult child witness, no audio or video transmission will be allowed and no photographs of the witness will be taken. At the conclusion of the adult child's witness's testimony, audio and video transmission of the hearing will resume and will continue through the remainder of the proceedings. The court finds that this procedure is narrowly tailored, uses the least restrictive means available, and appropriately balances the interests of witness safety and privacy with the public's right to observe these proceedings. We will proceed accordingly. We will take a brief, we will go ahead and clear the courtroom and go into a closed session. And the only remaining parties will be the attorneys, and we will take it from that point. The court will be in brief recess for 2 minutes.
All right.
Okay, well, they're going to be in brief recess for 2 minutes, but if they are not going to stream the witness's testimony, then we are probably going to be away for a bit longer than that. So my interpretation there, what he's done, first off, applause for once again, second time now, not just giving the parties what they want. Even the media has been like, yeah, sure, go ahead and close it. He's saying nope. And it may seem like for our purposes, like he hasn't really given us much. If it's not going to be streamed, we don't get to watch it, but it means there's going to be a transcript that's publicly available. And it does potentially mean that the audio or video could be released after the fact, just that it would not be live streamed. They would redact it or something like that. So basically just eliminating a lot of the just procedural hurdles that everybody ends up going through. I'm just going to assume this is not coming back in the short term. If it does, I'll bring it back. It's eliminating a lot of the procedural hurdles that we have to go through if they close the hearing, and then we got to have a whole other hearing on do we get a transcript and what part and so forth. They also, since the members in the audience are still going to be allowed to be present, any media that's there is going to be able to report on what's said, the substance of the testimony, how it goes, and all that. Now, can't say I necessarily expect real detailed and on point kind of description, and certainly even in the best case scenario, the descriptions that you get from somebody present in court are not a substitute for what you get to see with your own eyes. But this, this is a compromise, and it's frankly a more public friendly one than I expected. I really did think he would just say, yeah, go ahead and close it for her, because concerns about her being targeted when she is not somebody who kind of put herself, in a position to assume the types of, vitriol that the other participants in the case are being subject to. Not going that far. He's not going to make it, he's not going to spoon feed us. I would have liked the audio, but that's okay. As long as we can get a transcript, I'm not unsatisfied with this particular outcome. So I guess the reason why I don't like the no audio is because if they are there in court and they can hear it in court and we get a transcript of what's said in court, then that tends to indicate they're not going to redact it or anything like that for public disclosure, because it's already been public. It's already been aired in a format where people are allowed to be there and represent it and so forth. So why not just give us the audio? I don't know. But I do appreciate him not just bending over backwards. The parties say close it, him just, going along with whatever the parties want. Judge Graf continues to be one of our best advocates for transparency in the whole course of this case. Well, I didn't check the clock in the first hearing for how long the defense spent with Jeff Gray. It had to have been at least like 40 minutes, 45 minutes, and another 20 or so today. I just found that highly amusing that he wanted to make that record. And I know why he did. It's because if the court is going to put this sharp end timeline on when the evidence is being presented, they can't control the amount of time that a party spends on cross-examination. Of course, you can only control the amount of time you spend on your own direct. And so he's concerned about, well, if the prosecutors ask a whole bunch of unnecessary questions and stuff, they're going to run out the clock and then we won't be able to get to everything and then we'll be penalized for that. So he wants to make a record of how much time is spent. It's just that the relative comparison of the time spent so far doesn't really seem to be particularly favorable to the defense there. By my count, the state spent 13 minutes. Not particularly unreasonable in light of kind of the doors that were opened. So a lot of focusing on policy. Do you have policies? Did you follow the policies and stuff like that? This is part of kind of what I've described in the past as the fishing expedition that's being allowed in this motion. They don't have evidence of anything that's been done wrong, but they want to be able to explore the process and see if they find anything that was wrong with the process. And so they're looking into, do you have formalized procedures or standards or things like that? So then we can look at, did you follow them in this case, or did you maybe make exceptions or something like that for some reason that might have to do with the presence of the prosecutor's daughter? So far, they seem to have made a from my perspective, a pretty decent record that, like, to the extent there was inappropriate interference with the decision, I don't know about the charging, but at least to pursue the death penalty, it has nothing to do with the kid. It has to do with the president. It has to do with the governor. May or may not have to do with Kash Patel and Dan Bongino. But otherwise, yeah, they have a conflict policy. He didn't consult it, but he followed it because it's a pretty routine type of policy. And so, as it turned out, the way they handled it, he says, is consistent with the policy that they have. As far as the death penalty decision goes, he says that was made, between the 2 days between the arrest and the charging and the time when the notice was filed. He had made that campaign commitment that he would seek the death penalty in all appropriate cases. And so Utah, like any state that has the death penalty doesn't apply to any and all murder cases. It applies to murders that involve aggravated circumstances. And so some special additional fact. It's not just murder, it's murder plus. And so based on the presence of that additional fact, it qualifies for having a death sentence imposed. And the existence of those additional facts is decided by the legislature. So when they're passing the criminal laws that say, here's how we define the crimes and things like that. They also establish what they consider to be standards for the death penalty to be imposed. So the one that the prosecutors have alleged in this particular case is that the conduct endangered other people besides the victim. And that's why they have brought up repeatedly, there were people standing in front, there were people standing behind, because from a fact standpoint, it might be a little bit tricky to argue when you're talking about one shot on target from the type of firearm that you normally expect there to be. You can be pretty precise with a long rifle, particularly a scoped long rifle. And so this isn't a situation where, like a drive-by, where somebody is, going by in the car with a handgun that is very unprecise and they don't know how to shoot it anyway. The gangbangers they can literally hit everything but their target. It's quite a thing to see sometimes. But so just spraying bullets indiscriminately, for example, in a neighborhood, at a house, people are present. You see cases like this all the time. There, it's pretty easy to understand why a lot of people would be endangered in the situation. This one, I mean, I can see certainly why factually it might be a little bit more difficult to substantiate. It's going to be, for the jury to decide, of course, and everybody would get to kind of have their own thoughts about that. But assuming, for the sake of argument, that the state's theory of how the shooting went down is correct, it was long rifle from the top of the low C center, one shot, hit Charlie Kirk, in the neck where we all saw, no follow-up shots or anything like that. It's going to be a little bit more challenging, and it's kind of interesting because it intersects with this kind of idea that has proliferated that there's no way that Charlie Kirk could have been shot with a .30-06 because the human body won't stop that bullet, right? And so it's rare, I've seen plenty of stuff about it that goes back to like wartime injuries and things like that, because the .30-06 used to be, like, during, I think, World War II, certainly World War I, it was a standard military issue caliber. And so they ran into a lot of firearm injuries from people having been shot by a .30-06. And so I have personally seen, some studies from that suggest that was about 1 in 10 shots would not go through. So rare, not the most common, but also certainly not unheard of or undocumented or anything like that. But the reason I point out that this kind of intersects with this idea that, well, maybe it wasn't a .30-06 at all because it would have gone through, is that it would have gone through is also kind of what the prosecutor is relying on to support the death penalty. That, like, I think normally you would expect, yes, the .30-06 bullet would go through. This is a high-powered, high-velocity round. You would expect it to go through the target and then potentially endanger people behind him, people that are in the backdrop. So even though it's just one shot, that doesn't, it doesn't mean that once you hit your target, everything is all good and there's no further worries and stuff like that. So that's the basic justification for them seeking the death penalty in this case. The legislature has said endangering other people is a good enough reason. The prosecutors have argued there's evidence, at least probable cause, to believe that other people could have been endangered by this shot. Ironically, that may very well be based on the theory that a .30-06 doesn't normally get retained in a human body, so there would have been a risk if that shot would have gone through and it would have injured somebody in the backdrop. Obviously, they will have to reconcile that with the facts that they have here. It seems Seems pretty well understood that the bullet did not, in fact, go through. The bullet was retained, and we don't know a whole lot more about it than that because we don't have the autopsy reports or anything like that to give us clarity. What happened? Did the bullet fragment? Did the bullet hit bone? Different whole kinds of different things can happen when bullets intersect with the human body. So we don't have that explanation yet, and we're going to have to wait likely until our preliminary hearing to find that out. So that's their basis, and evidence that he has presented. The elected prosecutor was basically, look, I said I would seek it anytime it's appropriate. Don't really know what that means, right? That's kind of wiggle language from politicians. When is it appropriate? When you say so, it ends up being kind of like a self-referential kind of commitment that doesn't necessarily mean anything at all, other than if I want to, I will. And what kind of promise is that from a politician? So one possible way to interpret it is, well, if the statute, it can be satisfied, if there's evidence that would establish an aggravating circumstance, then there's been a legislative determination that it's appropriate. So anytime, I don't know. I would like to know. I honestly wouldn't have minded seeing that be explored a little bit more in depth by the defense attorney, just because, for one thing, we rarely get this insight into prosecutors' decisions to seek the death penalty or not seek the death penalty. If they're not in a context where they have to answer the question, then, it's easy to avoid it or to offer these kind of self-serving types of explanations and things like that. I would have loved to have a little bit more explanation about what does that mean to you when it's appropriate? Under what circumstances is it appropriate? Okay, you said you didn't have a written policy or a written standard for when you would do it, but you made this commitment. What did you mean by that? Did you mean anytime the statute can be satisfied? If not, then how are you going to choose? What other sorts of factors are going to come into play? And the reason why I think that is kind of a lost opportunity for the defense here is because it's awfully hard to believe that the high profile nature of the victim and the shooting itself didn't play a role in that. It's just kind of hard to believe, especially if this standard can be kind of, elevated to any kind of circumstance where a gun is fired and other people are present, and the bullet could go through or the bullet could ricochet or something like that. Just this kind of premise that anytime a gun is fired, potentially other people present could be endangered. That's an awfully broad standard, and I'd want to know, how consistently do you apply that? So I am a little surprised they didn't push harder on that, but they didn't. So all we know is just basically, if the prosecutor thinks it's appropriate, he'll pursue it. He made that promise, but we don't really know what that means, other than has nothing to do with somebody on the team having a relative who happens to be there. From his view, it had really nothing to do with anything. The couple of times when I made the comment about interesting, it had to do with the politics of it, the little kind of political comments that he made. He made the comment because he told the governor ahead of time, before he filed the notice, he told the governor that he would be filing it. So he told the governor that in the presence of Kash Patel and Dan Bongino. And he just made this kind of offhand comment when he was asked about, did that influence you? He's like, well, no, Patel was just there doing the business of the president or doing the bidding of the president. I'm like, wow, that's not a very flattering characterization, is it? Why don't you just call the guy a puppet? I mean, It just caught my attention. I don't know that he meant it like that, but that's how it came out. Like, wow. I'm not sure this guy had a very high opinion of Kash Patel with that kind of comment. So just interesting in the real housewives of the White House, policy, DC kind of thing. The personalities and how they interact and stuff like that. Just sometimes fun to see with these kind of players. What was the other thing that was kind of interesting? Let me see. I'm going back through the prosecutor's notes here. He talked about the Michael Jane case and the reason why they didn't wait in this case is because in that case they did, and there was going to be a news story where an anonymous source, where have we heard that before? An anonymous source went to the news media and said, "Oh, I've got inside information," and they're not going to pursue death. He had to contact them to set the record straight, and it subjects them to manipulation, by news media and public opinion and speculation and stuff like that. And for the benefit of the victims as well, who just want to kind of know what to expect, you're kind of leaving them in a little bit of a limbo state. And so then, particularly if there's a big media tornado going on, with a lot of people talking about, what's going to happen, and is it or isn't it, and why not, and all that type of thing. It's just not necessarily a good thing for the victims to have to deal with. So he decided he wanted to do it early in this case so that they would shut out that possibility. No uncertainty, no speculation. Everybody has clear expectations from the outset. And that makes some sense. Oh, the other thing that I was like, interesting was they were talking about the significant decisions that have been made already versus significant decisions that are still to be made. And they seem to be getting into this as kind of a fallback position, like just in case the court decides there is some kind of conflict here. What's the harm from it? How far does that harm reach? And so distinguishing like what's already been decided, which is basically just charging, and that has to be supported by probable cause. They're going to have to present the evidence to support a charging decision in the first place. And then also the death penalty, and they've made their record about how the death penalty wasn't affected by any consideration involving the child. But no plea negotiations. The most important decisions still haven't been made. Trial strategy, preliminary hearing strategy, and plea negotiations. That's very interesting because we have no way of knowing what the status of plea negotiations in a case is. And in a death penalty case, it's pretty routine for that to start real early. It comes up in, like it's in the defense standards. The ABA has standards for capital representation by defense attorneys. And one of those things requires that like pretty much from day one, you start investigating mitigation. And the reason why is because you need to have that available as a negotiating tool for the prosecutor to be able to go and show them why, even if otherwise statutorily the requirements are met, this particular individual is not deserving of death because of X, Y, or Z. Sometimes it might be they don't qualify. If you can establish somebody's got an intellectual disability, for example, we've got U.S. Supreme Court case law says you can't execute that person. That's probably the main limitation, at least under the existence of the law at this point. But you need to know that right off the bat, because if you discover that, you can take death off the table. You got a pretty good case for it anyway. Like prosecutor, why would you bother going through this whole process and trial and so forth to get a death penalty sentence that's just going to be overturned because legally it can't be imposed against this person. But most of the time that's not, you're not going to find that. But you might find other things. Death is supposed to be for the worst of the worst. It's not supposed to be for just any murder. I mean, it sounds kind of bad, I guess, to say, because of course human life is precious and sacred, and everyone matters. But that's just it's just how the law has evolved and unfolded is kind of accepted that just because somebody kills somebody doesn't mean they always in all circumstances deserve death for it. So huge part of the process is developing these reasons for sorting out why this person deserves death and why this other person doesn't. One thing that has been repeatedly coming up in the course of the filings, particularly involving press access and stuff so far, is this other case out of Utah, State versus Michael Anthony Archuleta. And the defense keeps raising the Archuleta case because it was a situation where the court allowed the preliminary hearing to be basically, it didn't close the preliminary hearing, but it sealed the evidence. So the evidence was not made available for public inspection. People couldn't come get copies and things like that. So the defense has argued repeatedly this Archuleta case provides a precedent for the court to take a kind of restrictive view of public access. There's several problems with this argument. Legally, the biggest problem is that there are rules now that the court has adopted that they did not have in place at the time of Archuleta. And so it's the rules that they have to follow. And courts are free to change the rules if it's not something that's of constitutional magnitude. So the argument would be simply they've changed the rules since then. Whatever they were operating under before this no longer applies, and so it's kind of irrelevant in that sense. But the other big reason was that Archuleta was an extraordinarily bad case. It was an extraordinarily bad case. It's so bad that I can't tell you how bad it is, or the stream is going to get terminated. It was two men that murdered a third man, tortured in some extremely gruesome and terrible ways. And killed him. And so that was really the justification for a lot of the the reasons why it was closed. It was extremely graphic, extremely just really, really bad. So a little bit, different in this case, not that it's not a bad killing, but it doesn't involve the types of injuries and acts and things like that were going on in the Archuleta case. But the reason why I kind of got on this sideline in the first place is because that was a death penalty case. Death was imposed. That guy is still on death row. It's been, I think, I counted before. I gotta remember in my head. I wrote a little bit about it on Substack, but can't remember now off the top of my head. It's been 35 years, I think. He's been on death row. It's still going on. Let me see. Oh, I got my notes right here. It was back in 1993 when he had his direct appeal. I want to say it was 89 when the murder happened, 90 when he was convicted. And so, yeah. Okay, 20 some years, I guess. And so, yeah, it's still an appeal. I actually just had a hearing on it back in state court. I've been kind of curious to see if maybe I could dig up some information about it. But I couldn't even really find any media reports, which was a little bit strange. But anyway, that is getting litigated over the issue I just mentioned, intellectual disability. The case is it's called Atkins. I think it's US v. Atkins. Holds that you cannot, under the 8th Amendment, execute somebody who has an intellectual disability, that constitutes a cruel and unusual punishment. Don't know, what the basis is or anything like that. That's what the hearing that they just recently held was supposed to be about, to present evidence of, does he have an intellectual disability? Does he not? That type of thing. But point being, kind of person who would do the kind of things to Mr. Archuleta is going to, I think, fit within pretty much anybody's definition of the worst of the worst. It's bad. It's just so bad. It's just so bad. And so it's not to say that what was done to Charlie Kirk is not bad. It's definitely bad. But there just are kind of levels to things like murder, even. So, job as defense lawyer is going to be looking at all of these different circumstances. Look, that guy Archuleta, he's still on death row. Look what he did. Compare that to what we're dealing with here. Yeah, it's bad here, but it's not that. Okay. And then look at our different people. Look at their relative backgrounds. Archuleta has a criminal history that is as long as a warm summer day. Okay. Not the days we're having right now. He's got a long record, long history of antisocial behavior and things like that. Our guy here doesn't seem to have a record of anything like this. It's your job to be looking for things like, who is he talking to online? How did his, we've seen these reports that his, it's in the probable cause affidavit, that his political viewpoints had changed. He had kind of become more radical. As the defense lawyer, you're going to be looking for, can I point the finger at somebody else as being kind of responsible for that? That, it's not that my client here is, just an antisocial monster who was looking to kill somebody and found an excuse. It's somebody who wasn't otherwise inclined to commit a crime like this, who was influenced negatively, for some other reason, and was able to be kind of convinced that this was the right thing to do. And the reason why that distinction is important is because you're talking about the possibility of redemption. Some people will never be redeemed, and that's really what the death penalty is supposed to be there, to kind of sort out those people. They're never going to be good people. They're never going to be people that provide a benefit to society. But not everybody who commits a crime is, without value. And some people do commit terrible crimes and do find ways within the constraints of, you're probably going to be spending most, if not all, of your life in prison either way. But they still find ways to add value, to be helpful to people, to try to turn things around in the best way that they can. So it's very interesting to me to hear that plea negotiations really haven't happened yet. I suppose on the one hand, it makes sense if the discovery is still, very, very much ongoing. Don't even have the digital discovery yet. That kind of thing, it can take time. So it's not super shocking to me, although, I would have expected October, it's been 4 months. No, 5 months. It's been just about 5 months now since Charlie Kirk was killed. Probably, 4.5 since they would have seized devices. Maybe taken a little bit of time to get all that collected. It can depend on a lot of things. If they have to force entry, if they don't have the passwords, don't have the pass key to be able to get in, then they have to break in. And that can be time consuming. That can sometimes take months. It just depends on how sophisticated the protection is. You know, it can be a remarkable difference between how easy it is to break a 4-digit password compared to a 6-digit password, for example. If there's no like biosecurity, those types of measures, don't recommend them if you don't want police to potentially have easy access to get into your devices. And the reason why is because there's a lot of case law that's out there that says that a password, you can't be compelled to turn it over. It exists only in your head. And so it implicates your privilege against self-incrimination to be able to provide that type of information. But just your body is not. Your body is open and out there to the world. And so police can compel you to give them your finger to unlock the biometrics, scan your eye, and whatever, the facial recognition. They can compel you to subject yourself to that type of opening process. But a password, they can't. So act accordingly. But anyway, so I guess if they had to break in to any devices, I could see a situation where yes, the time that it's taken to be able to get access to that data, get it downloaded, and so forth. Even though it seems like a long time because it's been 5 months, that's potentially reasonable. That's very consistent with the defense, the defendant, Mr. Robinson, no longer cooperating. Which, I mean, in terms of like official, doesn't seem like he's ever officially cooperated based on what we know from the PC affidavit. It indicates he made some incriminating statements to his family and turned himself in with their assistance, but no indication of any greater assistance that he ever gave on once he had surrendered to law enforcement. So not handing over your password would be consistent with that. Anyway, they don't have the digital data that is potentially, I mean, if I were the defense lawyer in this case, it's going to be extremely important information that I'm going to want access to be able to evaluate, if he did it, okay, which I, as a defense lawyer, I'm going to be in a pretty good position to have at least a good idea about. I know what all the other evidence is, and I've also been able to talk to my client about it, okay? My client says about defenses or things like that. But just hypothetically, if my client did do it, I'm going to want to look at why. And the digital footprint is potentially going to be an important part of that investigation. I'm going to want to be looking at who was he talking to online, what was he saying, because it might support an argument that, look, he wasn't a bad kid, he just fell in with a bad crowd. He was susceptible to this kind of extremist thinking for one reason or another. But it doesn't have to be who he is like forever. Seen arguments like this in like the best example I can think of off the top of my head is the Manson case with the different Manson family members, several of whom, sought parole, and largely based on they've come around, and the one that I'm thinking of most particularly is Patricia Krenwinkel. And the argument has been like, yeah, they were heavily influenced by this particularly, charismatic figure and the kinds of techniques that he used in his group. that kind of, got people, caught them and then, got them stuck closer and stuff like that. But that once she was, free from his influence for a significant length of time, no longer subscribes to those thought processes and things like that. Hasn't been successful for her, but it did work for Leslie Van Outen, didn't it? I think it did. I think she got paroled. I don't know. I don't always remember the specific details of all these things off the top of my head. But that's the type of thing you're going to be looking for. That's the type of thing that's going to be in your digital footprint. That could be partially an explanation for why there haven't been plea negotiations. Is it really like until you have your mitigation package kind of ready, you don't really piecemeal it. You need to kind of make your best case as much as you can in one shot. Because if you just come with something weak, you have a problem now with, you've kind of set the prosecutor's expectations of what your mitigation case is. You have a little bit of a, what's the word I'm looking for? There's a word, lost it, but when you it's white, like you don't give a number, because then that's what people will hear and they won't imagine a range or something like that. It's on the tip of my tongue and I can't find it. It's the same kind of idea with a bad mitigation case. You would get the prosecutor set in the idea that there's not a good case here for mitigation, and then when you come back with better evidence and better reasons, you now have to overcome. It's kind of benchmarking, but it's not specifically the word I'm thinking of. God, what's the word I'm thinking of? It's like there's like a word for it. I don't know. It'll come to me at 2 a.m. tomorrow. I about guarantee it. It's right on the tip of my tongue. So then you have to overcome the impression that you've already formed with the state by bringing a bad reason first. So you want your mitigation case to be complete. I suppose that could be a good reason. Yes. Thank you, anchoring. That's exactly what I'm thinking of. That is exactly what I'm thinking of. All of you, thank you so much. I was thinking of anchoring bias. That once you get that one thing and then you're stuck on that one thing and it's hard to move off that one thing, even if you get new information. But I just found it was interesting that they brought that out. That there haven't been any plea negotiations so far. Those types of decisions have not been made. They are still yet to be made. And so these are possible reasons why, because there's no mitigation yet. Discovery is ongoing, but we would expect video from UVU, potentially helpful one way or the other, but I would expect by now, he said 100% of what they had received so far had been turned over to the defense, not the digital, not the UVU video, but everything else. You got a pretty good idea at this point of whether the nature of your defense is factual innocence or just trying to avoid death. And it doesn't necessarily, mean that you're still going to fight the death penalty, even if, regardless of whether your client you got a good showing that your client is maybe factually innocent or not. But it certainly factors into plea negotiations in the sense of like what type of deal is even feasible. If you think your client didn't do it, you're not going to be receptive to just plead guilty to life in prison if you think you can prove that he didn't do it. So just a lot of intersecting decisions that get involved with this timing and nature of plea negotiations and so forth. But bottom line, my conclusion would be, well, it's just, discovery is still ongoing, and some of that important mitigation stuff, the digital evidence, is still not produced. No redirect from the defense. I was so grateful. Thank you so much. Thank you so much for not having to go in and nitpick everything that was just said. They do seem to find a way to adjust when there's a strict timeline from the court, don't they? I'm feeling like there's a learning process, a learning curve. Oh, they're back.
This issue. And a lot of this is repetitive, but being that this is a motion being made, I will put on the record the preamble to my ruling. The court has reviewed the parties' prior arguments and the materials submitted in advance of today's hearing, including entitled Proffer of Facts Regarding Closure of Portions of Evidentiary Hearing on Motion to Disqualify Utah County Attorney's Office. Defense has requested the testimony of certain witnesses, specifically Prosecutor A, adult child witness, be received in closed session pursuant to Utah Rule of Judicial Administration 4-202, citing concerns related to personal privacy and safety. The court acknowledges that Rule 4-202 permits limited closure of court proceedings in appropriate circumstances. At the same time, the court is required to consider the countervailing interests identified in Rule 4-202, including the public's right to observe the conduct of public business, to understand the operation of government, and to maintain confidence in the judicial process. The court must also remain mindful of the constitutional rights of Mr. Robinson, as well as the statutory rights of Ms. Erika Kirk in her role as victim representative. And I also note that she filed today notice in regards to open and transparent courts. So I just want to touch on that. I acknowledge that filing as a victim representative. The purpose of today's evidentiary hearing is limited and specific. The court is asked to consider the defendant's claim that a member of the prosecution team, which was previously referred to as deputy county attorney in the motions, has a personal conflict of interest, that any such conflict extends to the Utah County Attorney's Office, that disqualification is therefore required. The court's role at this stage is to receive relevant evidence and to rule based on the record and applicable law without reaching the merits of those claims in advance. The parties have filed public motions outlining the anticipated evidence and testimony related to the motion to disqualify, including the state's opposition, the defense reply and request to take evidence, and the defense original motion. Those filings describe the general subject matter expected to be addressed at this hearing. The defense asserts that the prosecutor's familial relationship with a witness creates a concurrent conflict of interest implicating Mr. Robinson's due process rights. The prosecutor's role, duties, and actions in this matter are therefore relevant to the issues before the court. If the prosecutor is called to testify, as it seems they will be, the court will consider the testimony as part of the evidentiary record. After careful consideration of the record, the arguments of counsel, and in the interests identified in Utah Rule of Judicial Administration 4-202, the court finds that closure of the prosecutor's testimony is not necessary and would not be narrowly tailored on the circumstances presented. The court further finds that the interests of openness and transparency outweigh the asserted grounds for closure as to that testimony, and the rights of the parties and witnesses can be adequately protected through least restrictive means available to the court. For those reasons, the request of both the state and the defense to conduct the prosecutor's testimony in a closed session is respectfully denied. You may call your next witness.
Not partially denied.
Your Honor, I call Prosecutor A.
All right.
Not partially denied, so we are going to...
And I assume from the court's ruling, we do not need to do a closed session as to his identity?
We will not be doing a closed session as to his identity.
Thank you.
Nope. With the child, it was partially denied. With him, it was just flat denied. Go ahead and confirm who it is.
All right, well, I'll go ahead and swear in the witness.
You solemnly swear that the testimony you're about to give now before the court will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
Mr. Burt.
Thank you. Good afternoon, sir.
Good afternoon.
Could you tell us your name, please?
Chad Grunander.
Mr. Grunander.
And could you tell us what your business or occupation is?
I'm a prosecutor at the Utah County Attorney's Office.
How long have you been a prosecutor at the Utah County?
Almost 22 years.
Sir, in front of you, there's a number of exhibits, and they're marked, I believe, D through G. Do you see those there?
Yes, I do.
Okay. I'd like to go over those briefly, and then we'll proceed with your questioning. Do you recognize Exhibit D?
I do.
And could you tell the court what that is?
This is a biography that lists my name, my title at the Utah County Attorney's Office with a brief description of what my duties are, my responsibilities, my education. It speaks to a little bit about my career and some of the cases that I've prosecuted over the years.
Your Honor, I'd move into evidence D, Exhibit D.
To the state.
No objection.
This exhibit is received and admitted into evidence.
Thank you. Next, Exhibit E. I wonder if you could identify that for the court.
Yes, this is an email that I sent to you as well as co-counsel for Mr. Robinson. It looks like I copied our prosecution team on this email as well. It was an email that was sent on the morning of October 1st, 2025, that disclosed an issue that came up with respect to this case that we felt was important enough to tell you, let the defense know.
Thank
This
you.
is my email.
I'd move E into evidence, Your Honor.
To the state.
No objection.
He is admitted into evidence and received.
And how about Exhibit F?
Yes, I see that. This is a photograph. It looks like it's a still shot from probably a TV screen from a Fox News alert that shows the amphitheater where Mr. Charlie Kirk was killed on September 10th.
And was this photograph used by you and an investigator to take some measurements out at the scene at some point?
It was, yes. In the middle of the photograph, you can see a dark bag. It's actually a dark blue bag that belonged to my daughter. She was at the scene on that day when Mr. Kirk was shot and killed. And I don't know if this was sent to me or I found it, but that just indicated where her bag was left behind when she left the scene. I used this along with an investigator to determine the approximate distance where she was standing when Mr. Kirk was shot and killed.
And what was that distance that you determined?
85 feet.
When did you make that measurement?
That measurement was done the day before, I believe, that I sent the email. So I believe that would have been September 30th of 2025.
Okay. Move that into evidence, Your Honor. Exhibit F.
The state.
No objection.
It is received and admitted into evidence. Thank you.
And Exhibit G.
Yes, I see that.
And could you tell the court what that is?
It looks like it's an email from Ms. Nestor, co-counsel for Mr. Robinson, that was sent to you as well as other attorneys, defense attorneys on Mr. Robinson's case. I became familiar with this document when you, Mr. Burt, sent this to me about 2 weeks ago or so. And that was the first time I recall seeing this and reading it. Some of it is redacted.
Right. Does that email, the unredacted portion, relate to a conversation that Ms. Nestor had with you on October 9th of 2025?
Yes, I can't say for sure it was October 9th, but we had a conversation on that day or right around that date over the phone, and Chris Ballard was also present with me. But yes, this reflects that conversation.
All right, and I move that into evidence, Your Honor.
As it relates to G.
Before determining if I object, I'd like to witness on the accuracy of this, the contents of this.
Let me ask if I could one more foundational question that could go to that.
Sure, we'll go to Mr. Burt and then to Mr. McBride. And so
Thank you.
it's not admitted into evidence just yet.
Did I send you that email for the purpose of you reviewing it and making sure it was accurate?
You did.
And did you have a response back to me as to whether or not it was accurate and how you would agree or disagree with the content?
I did. I don't know that it's word for word accurate, but the substance essentially is accurate. This is what we talked about and what was communicated.
All right. With that, I would renew the request to introduce G.
To Mr. McBride.
I will say, can maybe one.
Counsel, just no questions been asked. I'm just waiting for Mr. McBride.
If I can provide a witness about contents here.
You may.
Sure.
Grunander knows better. He knows he can't just volunteer.
Did you write this email?
I did not write this email.
This was an email that was sent between defense counsel that memorialized your conversation with defense counsel. Is that right?
That's correct.
Okay. I want to ask you about some of the contents here. Chad is sure he talked with a few people in the office about his daughter's presence. Is that accurate?
Yes, that's accurate.
Does that give a time frame for when you talked to the people about your daughter's presence?
This does not give a time frame.
It obviously had to be before October 9th, right?
Correct.
He definitely shared it with the whole, I'm quoting again, he definitely shared it with the whole prosecution team prior to notifying us. Is that accurate? Did you speak with every member of the prosecution team, meaning all the attorneys in your office, about your daughter's presence?
All of the attorneys assigned to this case?
Yes.
I believe so. I don't think I spoke to them each one individually, but they would have been present when it was talked about at some point, I'm sure.
Okay, let's see. Okay, I think that's all I have.
Thank you, Mr. McBride. And defense has renewed their motion to admit G into evidence to the state.
I don't object to the admission of G. The accuracy has been addressed by the witness. So,
all right. Exhibit G by defense is admitted into evidence. Mr.
Thank
Burt.
You want to make a clarifying comment?
I did. Right towards the end, before the redaction, it says his daughter has not been interviewed by any law enforcement. That was true at this time. I believe since then, she has been interviewed by law enforcement, my daughter.
Right. So when that was written on the 9th, she had not been interviewed by law enforcement.
That is my understanding, yes. That's
And
correct.
When was she interviewed by law enforcement?
I believe it was after our last hearing in between January 16th and today.
And can you tell me what role, if any, you had in arranging that interview?
I didn't have any role in that. I was just informed that it was going to happen.
Okay, thank you. Now, I'd like to direct your attention to September 10th, 2025. Can you tell me where you were around noon of that day?
I was up in Davis County, in Layton, at a convention center. I was there with my boss, Jeff Gray. I was actually presenting to the elected county attorneys in the state of Utah at a conference.
And was anybody else from your office present at that conference?
No, just the two of us.
Did something happen in relation to your daughter while you were at the conference?
Yeah, shortly after I finished presenting, we were standing around. I was standing next to my boss and some of the other county attorneys in the state, and I started to receive some texts from my daughter that were sent to our group, family text group.
And can you recall for me what the content of that initial text was?
Yes, there was a text that came in, I think at 12:25, I believe, that was in all caps, and it said someone was shot or someone got shot. There was another text that came in. I may have seen it at the same time, but it's the same timestamp that said something to the effect, I'm okay. Everyone's running inside.
Okay. And Just to refresh your memory, we were recently provided with some of your daughter's emails and screenshots, one of which was a screenshot of a outgoing phone call to you at 12:28 p.m. Do you recall that?
I do. I believe I actually tried to call her, and I don't think she picked up, and then she called me.
All right. And according to the screenshot, that was a 1-minute call. Do you recall what you said, what was said during that conversation?
I think I was checking on her well-being to make sure she was okay. I don't know that we even talked too much about the facts, what occurred. It was a short phone call, but I wanted to make sure she was okay. That's why I called.
Sure. What was your initial reaction when you learned that she was present at what probably you didn't know much about at that point?
Well, I was startled. I was concerned for her welfare. I understood almost immediately when I found out about it that she was okay, that she was out of danger, but it was concerning.
Now, did you know that she was attending this event?
I did. She had talked about it in the days preceding that she was going to go to this rally.
And did you have some discussion with her about whether that was a good idea, bad idea, or you had no position on it?
No position. We didn't talk about that.
And what did you talk about in relation to Charlie Kirk? This is before September 10th.
Just that I had become aware, probably through her, that he was coming to UVU. She would watch Charlie Kirk from time to time online, and she was excited to go see him at this rally.
Okay, so 12:28, you have this phone call with her. And then do you recall you communicating back with her by way of text?
Yes, I remember asking her a question a few minutes later, asking whether she heard what sounded like a gunshot.
And is that the reference? I think it's attached to the opposition to the motion as Exhibit B, an entry at 12:35.
That sounds right.
Hannah, did you hear a gunshot or what sounded like a gunshot?
That's correct.
That was from you to her by way of text.
Yes.
And did you get a response back from her?
Yes, she responded, I for sure heard it. Everyone started screaming and running. A few people said they saw the shot hit his neck, ... Not sure.
So at that point, did you share the email exchange or the text exchanges with anyone, either verbally or actually sending the text to anybody?
I know I spoke with Jeff Gray about these text messages. I may have even alerted him to the fact that there had been a shooting prior to even sending that text to my daughter, just because we were right there together. But we did talk about that briefly. Within a few minutes after receiving that last response, I know I called our office. I spoke with Chris Ballard to put him on notice that this had happened at UVU. I don't believe it had hit the media yet, news media anyway. And then shortly after that, I also called David Sturgill, another prosecutor in our office, to make him aware of it and to ask him to make himself available for questions and to assist law enforcement with any questions they might have while we, Mr. Gray and I, needed to travel down to Utah County.
And were you still at the location of the conference when you were making these calls?
I believe so, yes.
When did you actually leave to head to UVU?
Probably, I want to say I made that last phone call to Mr. Sturgill about 12:44. I think probably by 12:50 or so, I was probably on the road heading down to Utah County.
Do you recall, again, this is referencing Exhibit B to the opposition at 12:40, you sending a text to your daughter, quote, I'm getting live information, but I can't share it right now.
Yes, I remember. I think that was on the family group text.
Yes.
I think there was chatter on that group text from my sons. I think my wife as well. I think someone may have asked me, can you tell us anything or what's going on? And I just let them know I'm learning things, but I can't talk about it.
And when you say you were getting live information, who are you getting live information from? Do you recall?
Can you remind me what time that text was?
That was 12:40 PM on the 10th.
I do not recall, counsel.
Okay.
I think I had just communicated with my daughter is all. I don't know if in those text exchange, I don't know if my kids were online and seeing something through social media that they were sharing with me. I'm not sure.
Okay. Before you left to head to UVU, did you speak to anybody else in your office?
I believe it was just Chris Ballard, David Sturgill. It's possible I may have spoken with a legal assistant of ours, maybe Haley Christensen, maybe Tammy Painter, but I don't specifically recall that.
And of those people you spoke with, who did you mention your daughter was present at the event?
I don't have a specific memory telling Chris or David about my daughter, but that's how I learned about it. So I'm confident that I shared with them that my daughter was present when this happened, and that's how I found out.
Did you drive by yourself to the UVU?
I drove down to Orem and parked my car near the In-N-Out in Barnes & Noble. Jeff Gray met me there. He came down, left probably 15, 20 minutes later after I did. We met there, and then the two of us drove from that location to UVU.
And what did you do there at the scene once you got there?
We tried to understand what was happening. It was quite chaotic. There were a number of local law enforcement agencies that were already there present. Federal law enforcement agencies were arriving. We were trying to connect the dots as far as what had happened, make ourselves available to answer questions, to assist in reviewing warrants, for example, which did happen later. It was just very busy, very chaotic.
Sure. How long did it take you to get from the conference to the scene?
Oh, probably took me approximately an hour to get down there, maybe less. I waited for Jeff for a few minutes, and it probably took us 10 minutes to get into the command scene.
During that time period, did you have any communication with anybody about where your daughter was at that time?
I don't believe so. I don't know that I knew precisely. I'm confident I didn't know precisely where my daughter was at that time. Just that she wasn't in harm's way, at least at that point.
But at that point, you didn't know whether she was still at the scene or had gone.
I knew she had left because when we talked, I believe she had made her way to the parking lot and was waiting for a friend to go home. So I knew she wasn't at the scene itself.
When you got there, your understanding why she was gone?
When I got to the campus?
Yes.
Yes, she was gone by then.
Okay. Did you have some communication from anybody about a piece of property of your daughter's being there at the crime scene?
Yes, she had informed me that she left her book bag behind in the amphitheater, which is the subject of Exhibit F, in part at least. And that was communicated later that day to law enforcement that her book bag was there. It had her laptop, books and notes and things in it.
You didn't see it there when you were at the scene?
I actually did at one point take a picture because I believe later in the day I spoke with my daughter. I asked for a description. I don't think I knew exactly what her bag looked like. And I think I was standing on the scene and through a window took a picture of what ended up being her bag, sent that to her, and she said, yeah, that's my bag.
And did you request anybody in law enforcement that you have permission to take that bag at that point because it belonged to your daughter?
I just let them know that that was my daughter's and that as soon as the scene was released, as soon as possible, if we could retrieve that bag.
Do you recall who in law enforcement you spoke to while you were at the scene at the UVU?
I think I mentioned it once. She's with the State Bureau of Investigations. I should know her name, a female Polynesian. I know one of my co-counsel would remember her name. She helped process the scene.
All right. And did you mention to her or anybody else that your daughter was a potential witness at that point?
I'm sure I mentioned that my daughter was there and left a bag behind. I don't think I would have, I'm confident I didn't characterize it as she's a potential witness here.
Certainly didn't.
Or say that she was there during the incident that happened?
I probably communicated that.
And that would have been to one or more law enforcement people?
Correct. And I know I was also speaking with David Sturgill in my office about it because he was on the scene. I was back and forth to the office in the command scene at UVU over the next couple of days. And so I spoke with him about it as well.
Okay. And did, to your knowledge, anybody request to interview your daughter around the time of the 10th?
No, not to my knowledge.
How long did you stay at the scene that day?
I was at the scene. I don't believe I left to go back to the office that first day. We were probably there until 9 or 10 o'clock into the evening, maybe even 11 o'clock later into the day.
Now, at that point, you were the chief deputy in the office, correct?
Correct.
What were your responsibilities in terms of charging?
In terms of charging this case?
Yes.
I was part of the effort in deciding what charges were appropriate here. In our office, we have a policy that the county attorney, Jeff Gray, when any homicide case, he has to approve the charges. So I talked with Mr. Gray about the facts of this case as we understood them as they were coming in over the next few days. I'm sure I consulted with Ryan McBride, David Sturgill. They spent the better part of 2 days on scene, helping law enforcement. Chris Ballard, I would have talked to Chris about that. It would have been a team effort in large part, but the ultimate approval was Mr. Gray's.
You oversee the major crimes and general crimes divisions, correct?
I do.
And major crimes in your office includes homicides, I assume?
We don't have a homicide unit, but we have a special victims unit for sex crimes. And then we have a violent crimes unit. Most of our homicides are prosecuted by our violent crimes unit.
I would imagine.
But they're also specifically assigned given where the case gets, what court it gets assigned to, and the skill set of those attorneys and experience, et cetera.
Okay. Now, because of your connection in the case, did you become aware that on the morning of the 12th, early morning, that Mr. Robinson was arrested?
Yes.
About 4 o'clock in the morning?
I became aware of that, yes.
Okay. And are you aware that at 7:18 a.m. on the 12th, a affidavit of probable cause was filed by a state investigator by the name of Brian Davis?
I would have become aware at some point of that. I don't know exactly when, but I would have known that upon his arrest and booking, there would have been an affidavit attached.
And what role did you play, if any, in drafting that declaration, or at least overseeing it?
I was not involved in that. I didn't oversee that.
What was your role at that point in terms of overseeing what was going to happen to Mr. Robinson?
In large part, making sure that we had attorneys that were on scene at the command center available to assist law enforcement, communicate with Jeff Gray what we were learning about the case, trying to get the best understanding we could as far as what was happening, what the facts were, in anticipation of having to bring charges within the next few days. So as far as making assignments, I was probably speaking with Mr. McBride, Mr. Sturgill about their involvement, and just generally trying to learn about the case.
Were you aware of the media attention that was being devoted to this case early on before an arrest of Mr. Robinson?
Yes, I was aware. It was there was a lot of media involved. I remember going home the first night and it was all over the news media.
And were you aware that by September 11th and before the arrest of Mr. Robinson, that the governor of the state was announcing that the death penalty would be sought in this case?
I recall hearing that the governor had talked about the death penalty. I don't remember him saying it would be sought, but I remember him saying something to the effect that we still have the death penalty in the state of Utah.
What is I'm sorry.
Something to that effect.
What is your understanding of when the decision was made to seek the death penalty in this case? The date and time, if you know.
I wouldn't know the time, but I do recall early on, probably the second or third day, there was discussion that if we have the facts to support it, that Jeff was confident that he would be probably seeking the death penalty. I don't know if he'd made a hard decision on that on the second or third day, but he was definitely considering it.
If they have
When you
facts,
say the second or third day, are you talking about the second or third day in relation to when the incident happened on the 10th?
It would have been after, it would have been probably the 12th or 13th.
Okay.
It was following his arrest, I believe.
You're aware, are you not, that on the 13th, your office issued a press release, which included your name, indicating that we, the office, anticipated filing an information by the 16th.
I remember discussion about that press release. I don't remember the specifics of what was in the release, but that sounds right, because upon someone's booking, we have a certain amount of time in which we need to have an information filed, unless we seek an extension, and that would have been the 16th.
And so on the 13th, when that press release was released, had the decision already been made to seek the death penalty in the case?
I don't know, counsel. I don't have. So the 13th, this happened on the 10th. So the 13th, that was a Wednesday. It may have been made on that day, but I'm not entirely sure.
Or it could have been made before that day. True.
I suppose. But that would have to be a question for Jeff Gray to know for sure.
Well, as a chief deputy in the office, is that a decision that you normally would have been part of the process and deciding?
Oftentimes, yes, and I'm sure that Jeff ran it by me, but by the time we were talking about the death penalty, my role was, do we have the facts to support an aggravating factor under Utah law that would support a potential death penalty case? But I don't remember a conversation with Jeff Gray where he asked, what would you do in this situation? But there would have been discussions, I'm sure.
Who in your office at that time, around September 10th, had more experience than you in prosecuting homicide cases?
Maybe Tim Taylor, who's now in our civil division. That might be it.
Within the criminal
division, probably no one.
And had your role in prior cases been such that you were consulted on the decision of whether to seek death or not?
In this case, was I consulted?
Now,
or in other cases?
Let me rephrase it. My apologies. In other cases that you have been involved as the lead prosecutor, was it routine for Mr. Gray to seek your advice as to whether to seek death or not in a case that you were primarily in charge of?
Yes.
And can you give me an example of where that had happened?
The prosecution.
Objection, relevance.
same,
Counsel, could you repeat the question that you asked? I want to make sure I'm ruling on this.
The question is, can you give me, you had said there have been cases where he's consulted you on whether to seek death or not. I asked you whether you could give me an example of such a case. And that was the objection.
All right. And as to relevance, Mr. McBride, I'll hear your argument.
what his role has been in the past, and talking about he's already testified he has had a role in those discussions in the past. Now we're asking what specific instances he has had involvement. I mean, I don't know. We're going to get into the facts of these cases. We need to bring this back to the question, which is, what role did his daughter's presence at the event have on the decision making in this case? That's what we need to get to, and I don't think how it's happened in other cases is relevant here. We move along. We got 45 minutes until this hearing ends.
Pattern of practice.
Thank you, Mr. McBride. Mr. Burt.
I think Mr. Gray referenced in his opposition, his statement that the reason he was seeking the death penalty in this case was because of what happened in the Janes case. And I believe that this witness was the lead prosecutor in that case, was consulted about the death penalty, so it relates directly to what Mr. Gray testified about.
I will overrule the objection, but counsel, we're not going to go far down that path.
I understand.
Thank you.
Go ahead.
Yes, Michael Jane is a current prosecution. It's an aggravated murder case that I'm currently the lead prosecutor on.
All right, and generally in your office, is Mr. Gray typically involved in hands-on litigating a case as opposed to being the administrator in the office?
No, not typically.
Okay, and in cases where he's obviously the county attorney, but you're prosecuting a case, it's typical for him to seek your advice on whether to seek or not seek death.
Seems reasonable.
Correct?
Sure.
Talk to the guys doing the work. Have to convince the jury.
On September 16th, your office filed a notice of intent to seek the death penalty, correct?
Yes, I believe it was Jeff Gray that actually prepared that notice and caused it to be filed.
And what discussion, if any, did Mr. Gray have with your team regarding whether that notice should be filed at that time?
I remember Jeff expressing to us that that the decision was made. He'd made the decision that he was going to announce the death penalty, seek the death penalty in this case. He wanted to do it earlier rather than later, and decided to do it at the same time we charged the case. And so I don't know if it was filed. I think it was filed a few minutes or so after the information was filed, but it was filed prior to Mr. Robinson's first appearance, which occurred later that afternoon on the 16th.
In the opposition to our motion, Mr. Gray indicates in reference to the Jane case, quoting here, the county attorney concluded from the outset that he would seek the death penalty, but choosing to follow the convention of some, the county attorney initially opted to wait until after the prelim. Do you know what he was referencing when he referred to the convention of some in terms of what the practice was?
The statute calls for, I think it's within 60 days after arraignment, which takes place after a preliminary hearing, is when the notice of intent to seek death needs to be filed. Many prosecutors wait until after a preliminary hearing to file that notice. In Michael Jane, we didn't, but it was a handful of months or so after the information was filed before the notice of intent to seek death was filed. So I think the majority of cases, that notice of intent to seek death is probably filed after the prelim.
And do you know the reason for that policy or that practice?
Probably, well, I can give you I think you may have a better understanding as far as the strength of the case, where it's headed. There may have been plea negotiations that occurred in between that time. So could be for a few reasons.
Also, you might know a little bit more about the defendant's background by that point.
Sure. On the mitigation or aggravation investigation, sure.
Mm-hmm. Have you ever had a case in your office where a decision was made to seek the death penalty solely on the basis of the facts of the crime without regard to the defendant's background?
I'm not
Archuleta.
aware of that.
Archuleta.
Now, let me ask you a couple of
Pretty
questions
sure.
about Exhibit E, and then we're almost done here. Exhibit E is your email to the defense in which you state, "We don't believe the following creates a conflict for me in Tyler Robinson's case, but it's something that should be disclosed to you, his attorneys." And then you outline basically what we've been discussing here today, correct?
Correct.
And can you tell me how that decision was reached to send this email to the defense, what the considerations were?
Sure. The considerations were that I would be part of the prosecution team. I would be assigned to this case to help lead this team. And my daughter was present. And there's an argument that can be made with respect to a conflict. And so our practice, my practice, is to, if there's an argument, disclose it. We're not in the business of hiding anything. And so we knew from the outset that once counsel was appointed, that we would be disclosing this to the defense, and they would respond accordingly, however they thought they should.
Reference has been made to these Utah prosecutors' best practices, Exhibit I. You're familiar with those?
Exhibit I, not specifically, but.
Let me show you that. Did I approach on it?
The stream has frozen. Let me get me out of the full screen and see if. All right.
Yes. It's 29 pages long, so you'll have to refer me to.
I'm not going to ask you to read the whole thing, but you're generally familiar with that, right?
From time to time.
And there's a statement in there, I'll read it to you, which says if there's close cases should be resolved in favor of disclosure in a situation where there might be a potential conflict.
Sure, I would agree with that.
And did that motivate your behavior here in terms of why you disclosed what you did in that email?
As far as it being close, is that the question?
He's sharp.
Did that motivate your behavior in disclosure?
What motivated my behavior was to just act with professionalism and integrity. Disclose this to the defense.
What a good answer.
Don't mistake our disclosure, my disclosure, our abundance of caution, our professionalism, integrity to be a concession that we believe there's merit to this alleged conflict.
Sure. And you realized in disclosing that the ultimate decision is really the court's, right?
Correct.
All right. And there's a section of those guidelines that says if a prosecutor believes that public perception of the integrity of the prosecutor's office and public confidence in the handling of the case would negatively be impacted by a potential or alleged conflict of interest, the prosecutor should consider recusal. Did you take into account that standard when you were making decisions about what to disclose and what the significance of the fact was that your daughter was present at the scene?
Sure, we considered the appearance of conflict here, but when we learned and had a good grasp of what her experience was, or perhaps most importantly, what her experience wasn't, what she didn't see, we felt confident that there's just simply no conflict here. And once people become aware of the facts, there's no appearance of conflict.
Now, you had made that disclosure to us on October 1st, correct?
Correct.
When had you conducted the investigation about the measurements?
The day before.
The day before.
Mhm.
And do you know when Mr. Gray conducted the subsequent investigation into whether you could see her position from where the alleged shooter was?
That was much later.
So that part of the investigation had not been done at the time you decided there was no conflict.
That's correct.
And similarly, no one in law enforcement had interviewed your daughter, independent of you and what we see in the text, prior to you deciding that there was no conflict here, correct?
Yes.
Lastly, I wanted to ask you about the email from Ms. Nestor that summarized the conversation you had with her, because you said there was maybe some clarification needed there. She said in the email, Chad is sure he talked with a few people in the office about his daughter's presence. When did those conversations take place?
It would have started almost immediately after receiving her text. I spoke with Jeff Gray about that. He was made aware of her presence. Within minutes after I made a phone call to Chris Ballard and then David Sturgill, I'm confident that I mentioned to them that she was present.
And that email then goes on to say he definitely shared it with the whole prosecution team prior to notifying us. Is that correct?
Yes, I believe so. I think we talked about this issue, and it was decided as a team that, yeah, no question, we're going to disclose this. So I'm sure it came up.
And was that in one meeting? Was it in several meetings? Was it discussing it with each team member individually? Or give me a better sense of that.
I don't know that I spoke with every team member individually, some of them for sure. Mr. Gray, Chris Ballard. I'm sure I had conversations with Ryan McBride and David Sturgill as well. I don't know about Lauren Hunt. Lauren is on this case as well, other than outside of a team setting. So there would have been discussions as a team and then also individual discussions.
I see. Could I have one moment, Judge? I think I'm done.
Of course.
He is such a better
Mistake.
witness than Jeff Gray.
Will you please describe the effect when you learned that your daughter had been present on September 10th? Over the next maybe 8 hours, you drive down to Utah County, you drive to Utah Valley University. What effect, and you're interacting with law enforcement, what effect did your daughter's presence have on the discussions you're having with law enforcement, your work as a prosecutor at that point?
Other than informing the investigator, I can't recall her name right now, about her book bag being present, putting law enforcement on notice that needed to be retrieved once the scene was released. It was busy. We were trying to learn about the case, the facts of the case. I don't know that I talked much, if anything, about my daughter's presence there. The effect it had on me, I was obviously concerned when I first heard and saw these text messages. That's why I called her to make sure she was okay. She was out. She wasn't in danger any longer. And then there was work to be done. And so we got busy trying to understand what had happened that day and start to put the pieces together. I'm sure I reflected on it from time to time, but I don't specifically recall.
Okay. Did it affect any decisions you made as to what you're doing as an attorney out at the scene?
No, absolutely no effect.
As far as the charging decisions, there's been some discussion or testimony about how the charging decisions were made in this case. Did your daughter's presence have any influence on the charging decision that was made in this case?
No, none at all. What was important was, did we have the facts, substantial evidence to support an aggravating factor? And look at the case law. And there's the Johnson case, the Pierre case, the Sosa Hurtado case. I was researching those cases, considering the zone of danger, if you will, which is talked about, I think, in the Johnson case. And it was clear that my daughter was not within the zone of danger. It had no effect.
Okay. Did it have any effect on the death penalty decision? Your daughter's presence?
Not from my perspective, and I don't believe it had any effect on Mr. Gray's perspective.
Was your daughter's presence discussed as that decision was being made?
No.
Has it had any effect on the decisions that have been made in the prosecution of this case since?
No.
Now, as a father, have you monitored your daughter's condition?
Sure. Her emotional condition?
Yes.
How well of course.
And what's your understanding? How has her presence affected her? Has she had to get therapy?
No, she has not.
Has she had to miss work or school?
No.
Have you noticed a change in her demeanor or behavior at home?
No.
Just a moment, if I may.
Not a whole lot there to work with. I mean, nothing factual so far that's been developed significantly beyond what they already had in the motion. So in some respects, this is a big waste of time. Some other things might be helpful for other purposes.
Your conversation with her. Once again, you were asked, or one of the statements in there is that you talked to the whole prosecution team about your daughter's presence. What do you mean you talked about your daughter's presence? Just that she was there, or what? And I want to ask you this question outside of the current motion to disqualify, because I know that this motion to disqualify has brought her presence into center focus. But outside of this motion to disqualify, what did you mean you told others or you talked to others about her presence?
Well, I had informed them that my daughter was there when Charlie Kirk was shot and killed. She was at the rally. And I'm sure we talked about what her experience amounted to based upon the text messages that I had received. I know we talked about my disclosure, the disclosure email. In there, I talk about her emotional state. So I probably shared with them that she seems to be doing fine, that she hasn't needed to speak with a professional about it.
Okay. Did you learn anything from your daughter's presence that you hadn't learned from other evidence in this case?
No.
For example, that Charlie Kirk had been shot and killed.
That's correct.
Did you learn that from your daughter's presence, or did you learn that from other evidence in the case?
Well, both, because she informed me that it looked like Charlie was shot. So I would have initially heard that from her. But there is other evidence, yes, direct evidence.
Would her testimony be admissible in trial?
I don't believe so.
That Charlie Kirk was shot and killed?
I think that calls for a legal opinion.
It's
Counsel?
true, it does.
It's probably true.
I'll sustain the objection.
Very fair judge, even-handed.
Let me make sure I've just asked that question adequately. Was there any information you gained from your daughter that you did not gain from other evidence that was collected in this case?
No.
Thank you. Nothing else.
Thank you, Mr. McBride. May this witness be excused. Oh, I'm sorry, Mr. Burt. Thank you.
You mentioned that the decision to seek death was based on the assessment of whether the aggravating factor was present or not, correct?
Correct.
And the aggravating factor is creation of danger to other people in the zone of danger.
Was another put at great risk of death?
Is the way the statute reads.
Correct.
At the time that decision was made, had you done any investigation yourself on who was or was not in the zone of danger?
We, I believe, as early as the second day, and I'm referring to, I think, the 11th, walked the scene as soon as law enforcement released the scene. And I positioned myself up on the shooter's perch, if you will. And at that time, I knew, based upon the photographs, of where my daughter was. And given where the shooter was and shot and killed Mr. Kirk, yes, I would have known that she was not within the zone of danger.
And nor
by the second day.
And the measurements you took in that regard took place when? End of September?
End of September.
Okay.
That's correct.
And that was the first measuring that you were involved with or that you were aware of?
Yes.
Thank you. That's all I had.
All right.
Your Honor, I do have a follow-up on that.
All right, Mr. McBride.
I want to ask you a little bit more about that zone of danger. Were you aware of other evidence that there are other people in the zone of danger?
Yes, absolutely.
What kind of evidence?
There was a substantial amount of social media evidence that was coming in, videos of the actual assassination of Charlie Kirk. There was the questioner that stood in front of him asking the question when he was shot and killed. There were others near him. There were people to the left and to the right of Mr. Kirk, people right behind Mr. Kirk as well, several individuals.
And that testimony and that evidence, does that come from your daughter?
No.
Comes from other people who recorded the incident. Is that right?
Correct.
Same question. That's probably all we have for redirect. Thank you. Nothing else.
Thank you, Mr. McBride.
Yep.
Anything further for this witness?
No, Your Honor.
May this witness be excused.
Yes.
Thank you, Mr. Grunander. To defense.
Your Honor, at this time, we don't intend to call any more witnesses, and we would submit on our motion. I do believe the state may have a witness or two.
All right, turning to the state.
You want to bring in the videos now? I guess we'll see. That was smart to turning it back to, okay, you decided your daughter wasn't in the zone of danger, but that doesn't necessarily get you out of, but you're in a potentially conflicted position to make that decision.
Standing right by the lectern when you'll be sworn in.
So come right back with who was in fact in the zone of danger and how did you determine that?
All right, Sierra, if you wouldn't mind having a seat right there, adjust the microphone. There should be a bottle of water if you get thirsty or dry. And just bring that microphone a little bit closer just so that the record picks you up.
We got a guy with some binger hair here, kinda.
All right, Mr. McBride.
Before we turn to Sergeant Hull, the state has submitted an affidavit from Agent Cole Christensen. I've just conferred with counsel. I think we're both on board that the court can consider that in reaching its conclusion on this matter today. Save us having to call him as a witness.
All right. What was the proposed exhibit number for that?
It's an attachment to the state's pleading, addendum C.
And so how is it going to be marked? Just for record keeping for this hearing?
Let's call it State's Exhibit 13. Pardon marking that.
All right. The state is moving that into evidence to defense. Any objection?
Your Honor, I think it's already been submitted and attached to the motion, so no objection.
All right. State's Exhibit 13 is received into evidence in this case.
Will you please state your name?
Agent Dave Hull.
And what is your position?
I'm an investigative agent with the State Bureau of Investigations.
What is your role?
Your Honor, could you ask him to move that microphone a little closer? I'm having trouble hearing Agent Hull.
You need to bring the microphone almost to the point where it's uncomfortable to you. So bring it forward. And we just want to make sure the record picks you up.
Okay, is that better?
Yes, thank you.
He's got a bit of an accent.
I want to ask you about some of the evidence collected in this case. Are you aware generally of the evidence that has been collected in this case and the investigation that has been done?
I am, yes.
First off, will you describe basically the scene where Charlie Kirk was killed when he was shot and killed?
Yeah, the scene is essentially an amphitheater setup. Mr. Kirk's stage was set up at the base of the amphitheater. And then there are, I guess, semicircular tiers that move back up and away from the stage area, creating the amphitheater.
And how many people approximately were present?
Estimates for attendance at the event itself were about 3,000 people. And then the campus was open to regular students that day also.
How did the State Bureau of Investigation determine who to interview of those 3,000 people?
There were several processes used. There was a general request for information that was put out for people who attended the event. There was a time when people who had attended the event returned to collect personal belongings, and posters and requests were made for people to provide information. People who had volunteered information. So several different sources and several different ways that we made contact with the public.
Okay. And were all of the witnesses of equal value, those that were present at the event?
Essentially, yes. There were one or two who were able to provide different information, but essentially the majority of people who provided information provided confirming or repetitive information about their experience.
Okay. I want to ask you about videos that were collected. Well, first, do you have an approximate number of how many witnesses were interviewed out of those that were present at the event?
I know that as a state entity, we're able to obtain over 40, what we would call an 1102 or a witness statement, which is a written statement. I also know that the FBI provided us with a number of written statements and interviews that they conducted also.
So did you say 40?
Yeah, at least 40. It would be more than that.
Okay. Plus FBI collected additional statements?
Correct.
Okay. Did you collect videos that some of these people had taken?
We did, yes.
I would like to present State's Exhibit 1.
I'm with Amy here. I'm thinking South Africa. It doesn't sound British. There's too much twang in it, but it's got too much flat part to sound Australian or Kiwi. Just to me, I'm leaning towards South African.
Are you doing it again?
You should see it appear on your screen in a moment.
Wonder if we'll ever find out. Yeah, it could also be like one of those mixed things where he grew up somewhere, but he's lived somewhere else so long that the accent has gotten a little, altered, a little distorted.
Okay, if you can just pause that for a moment, Kimberly, thank you. You recognize State's Exhibit 1?
I do, yes.
What is that?
That was a video provided by an individual named Mr. Lyman, who was behind where the stage was set up. There's a kind of a walkway that goes under a building. And then behind that, there were vehicles staged, and that's where Mr. Kirk arrived on the scene.
For the purposes of this hearing, I'd move the admission of Exhibit 1.
No objection.
It's received and admitted. Thank you.
Please play that video. Okay, will you describe where this is we're seeing, or what we're seeing and where this video is capturing at this point? And we are at 14 seconds into the video.
This is Mr. Kirk's arrival to the event. As I mentioned before, that kind of concrete breezeway that was behind the stage area. Mr. Kirk made his way through that. And then he would have been stage right when he first entered into the amphitheater. I didn't know at the time, but I guess he has a tradition of throwing out hats to the audience, and so that was what he commenced doing at that time.
Okay, and then in a minute, we're going to see the video capture the actual amphitheater area. Is that accurate?
I believe so, yes.
Okay, go ahead and hit play, please. Thank you. Are there other videos that the Bureau of Investigation collected that capture the crowd in the event?
Yes, there are numerous videos that were collected from individuals who had been attendees at the event, and also videos from the university itself.
Meaning University of Utah Valley University surveillance footage?
Correct, yes. Utah Valley University has a comprehensive surveillance system.
And Turning Point USA, Charlie Kirk's organization, did they also capture videos of the event?
They did, yes.
I'd like to show you State's Exhibit number 2.
So we're not going to see any of these videos. We're just going to hear them. However, by becoming exhibits,
I
they
have in
are
front of you
public
State's
record.
Exhibit number 2. Do you recognize that?
I do, yes.
And is that a video that's collected in the investigation in this case?
It is, yes.
For the purpose of the limited purpose of this hearing, I'd move the admission of Plaintiff's Exhibit 2.
Defense.
No objection.
It's admitted. Thank you.
Okay. Will you describe what we're going to see here before we hit the play button?
Yeah, this video will actually zoom into the roof area of the buildings. You can see center screen. In doing so, the video will capture an individual on the corner of the rooftop.
Was this video captured by the person we're referring to as Prosecutor A's daughter?
No.
Okay. Please press play.
You think he'd already be in place? You would think that. So there's somebody on the roof right there? Just saying. He just ran from over, where's my finger? Well, from over there, ran in, and now he's right there. Just saying.
Now, that roof that was recorded in that video, first, is there other surveillance of that person in that location at that time running to that spot?
There is additional footage, yes.
Where does that come from?
That came from the Utah Valley University security cameras.
All right. Is there another individual that also recorded a person running after the shooting from the roof?
Not to my recollection, no.
Any video from someone, you recall a video from someone in the Hall of Flags who may have recorded someone running after the shooting?
Yes, there was an individual who recorded from the Hall of Flags. It's an interior video looking through the windows. But I believe an individual is visible on the rooftop also in that video.
Okay, thank you. As far as other witnesses, some of the other relevant witnesses in this case, who is Hunter Kozak?
My recollection is he was the individual who was asking the question to Mr. Kirk at the time that he was shot.
Okay. Would he be a witness in this case? Could he be a witness, I should ask?
Potentially, yes.
Okay. Where was he positioned in relation to Mr. Kirk?
I believe the way the stage was set up, he was approximately the same height level of Mr. Kirk, but he would have been directly in front of him where they had the barriers set up separating the crowd from the stage area.
Okay. I would like to show you Exhibit 4. Now, Exhibit 4, this is a screen capture from a video. Do you recognize Exhibit 4?
I do, yes.
You remember the video from which this is taken?
Yeah, it was a cell phone video belonging to an attendee of the event.
And that attendee was not the prosecutor's child?
It was not the prosecutor's child, no.
Will you describe what the video shows?
If I recall, this is a graphic video that does actually show the time that Mr. Kirk is impacted by a projectile and the subsequent trauma and reaction of the crowd.
Okay. Does it show the position of the people to his right and to his left?
Mr. Kirk's right and left?
Yes.
In a limited manner, it does, yes.
Okay. Does it show the position, the video, we're speaking of the video, does the video show the position of the questioner, Mr. Kozak?
I don't recall if it pans all the way to the question asker or not specifically, but there is potential that it does, yes.
I'd move the admission of Plaintiff's Exhibit 4.
No objection.
It is admitted into evidence.
Did you interview mothers with children that were at the event?
I believe there were some mothers who had children at the event who provided witness statements to the State Bureau, yes.
Okay. I'd like to show you Plaintiff's Exhibit number 5. Do you recognize Exhibit 5?
I do, yes.
And this, my understanding is this is also a screenshot from a video from Turning Point USA. Is that accurate?
Yes, this was a video taken by Turning Point USA.
Does this show the questioner, Mr. Hunter Kozak, in front of Charlie Kirk?
It does. You can see him holding the microphone just above Mr. Kirk's head.
Okay. And the video, will you describe what the video shows?
From my recollection, this video also shows the point that Mr. Kirk is struck by a projectile, and it shows the reaction of the individual asking the question, along with the reaction of Mr. Kirk's security detail and those others in the crowd.
Okay. I also see another, I'll leave it at that. From what you have gathered in the investigation, were you able to determine the direction from which the bullet came?
Yes.
And in this Exhibit 5, where would that direction have been?
Essentially from straight in front of Mr. Kirk.
Okay. And which side of Mr. Kirk's body did the bullet strike him?
It would have been his left.
All right. All right, and finally, Exhibit number 3. Oh, did I move the admission of Exhibit number 5?
No objection.
It's admitted.
Avoiding the defense objections by not putting the video in, just the screenshots from the video. Clever, clever.
I have Exhibit number 3 up in front of you. Do you recognize that?
Yes, that's a university or a Utah Valley University video of the kind of the breezeway area that I previously described.
And Exhibit number 3 is a screenshot from that video. Is that right?
Yes, that's correct.
And will you describe what plaintiff's exhibit, well, the video itself actually shows?
Yes. If we were to play this video, this shows also the time that Mr. Kirk was impacted by the projectile. And it shows the activity that occurs behind the stage area and the movement of people prior to, during, and then after the incident. On both sides of the breezeway where the barriers are, the crowd actually break through the barrier in an effort to escape the area.
Does this video show others that may have been exposed to risk if that bullet would have missed Mr. Kirk?
I believe so, yes.
Any of those Prosecutor A's daughter?
When you responded on September 10th, did you know who Chad Grunander was?
I did not, no.
Did you know anything about his daughter?
I did not.
Did you eventually learn that a prosecutor's daughter was on the scene?
I did.
When did you learn that?
I believe when I found out, it was when the motion had been filed for the conflict argument.
Okay, so prior to that, did the presence of that person, that individual, have any bearing at all in your investigation in the case?
No, I was not aware of her presence at the event.
You have read that adult child's affidavit in preparation for this hearing, right?
Correct, yes.
And was there anything in that affidavit that changed your view of the case or the investigation you should do?
There was not, no.
Was there anything new in the affidavit?
No.
You're here for her testimony today, correct?
Correct, I was.
Same questions. Anything new in that testimony?
No additional information.
Now, I want to ask you a little bit about the value of the witnesses as it relates to this case. Did the witnesses on scene identify the shooter?
No, we did not have a witness that identified the shooter on scene.
What was was that the primary goal of your investigation, to identify the shooter?
It was, yes.
And I want to ask you about the existence of other evidence. You said you collected surveillance evidence from Utah Valley University. Is that right?
That's correct.
Did that give you some additional information on identifying the shooter?
It did, yes.
How about doorbell cameras for the areas around Utah Valley University?
Yes, we collected a large number of doorbell camera footage from multiple residences in the area. not just in Orem, but also in St. George. And we also recovered video footage from multiple businesses in the area of the university campus in Orem, and also from businesses between Orem and St. George. So there's a large amount of video footage obtained.
And did those help you identify the shooter?
They did, yes.
Text messages, did you collect text messages from associates of Tyler Robinson?
We did, yes.
And did those have any evidentiary value?
They did, yes.
How so?
Some of the communications between Mr. Robinson and people that he knew indicated that he had been involved in the incident at Utah Valley University.
Okay, and you say that indicated he'd been involved. What do you mean by that?
There was, I don't recall specifically with text messages, but some of the social media chats, there were admissions that he had been involved in the incident as the shooter.
So more than just
CSI evidence. Was CSI evidence, crime scene investigation, collected in this case?
It was, yes.
Was DNA evidence collected?
It was, yes.
Does that evidence help you identify the shooter?
It does, yeah. The evidence that was obtained did provide us with DNA evidence in relation to items used during the commission of the crime, and then they were compared to Mr. Robinson.
Okay, items used meaning what?
Specifically, a screwdriver that was recovered on the rooftop of one of the buildings, and a firearm that was recovered in a tree area on campus.
And you didn't do the DNA testing yourself, correct?
I did not, no.
But you're aware there have been reports that have given evidence as to the identity of DNA on that rifle.
That's correct, yes.
Was a search warrant on the defendant's house executed in this case?
It was, yes, down in St. George.
And was evidence obtained from his house?
It was, yes.
What kind of evidence?
Kind of putting me on the spot, but if I recall, there were some bullet casings that had some inscriptions on. There were some tools that were believed to have been used to make those inscriptions. There were targets, I believe, that had been used, and also targets that had been purchased recently or just prior to the event. There was ring doorbell camera footage obtained from other residences down there. And then a number of electrical items, laptops and such that were collected as part of the warrant.
You said inscriptions on some shell casings found in his apartment. What value do those have?
That was relevant because the shell casings recovered with the firearm also had inscriptions on them.
You said there was evidence. The DNA was evidence consistent, or DNA consistent with the defendant's DNA found on that rifle.
Object to hearsay.
Counsel?
This really ought to be considered under kind of a 104 rule of evidence here. We're not offering the admission of this to prove guilt, but whether or not there's a conflict of interest, the existence of other evidence besides the adult child in this case is relevant to whether or not she is a material witness. If we've got DNA proving or suggesting or proving otherwise, it's directly relevant to that. And under 104, the court can consider it.
All right. Ms. Nestor, anything further?
No, sir.
All right. Based off, so I will overrule the objection based off Rule 104, and as it relates only to this hearing today.
Understood.
Sorry, could you repeat the question?
Is DNA consistent with the defendant's DNA found on the firearm that was found at the scene?
Yes, the DNA on the firearm was consistent with that of Mr. Robinson.
You said the etchings, there was etchings in that firearm, and that there's also etchings in rounds in the firearm. Is that what I understand?
Yes, I believe the chambered round and other rounds found at the time had etchings upon them.
And you said there are rounds with etchings also found on them in the defendant's apartment. Is that right?
That's correct,
What did
yes.
they say?
Okay. That firearm, where was that found?
It was found in a wooded area just off of Campus Drive, wrapped in a black towel.
Okay. How critical are eyewitness statements of those present to the event to identifying the shooter?
They did not provide any information that allowed us to identify the shooter.
Okay, if I can have just a moment. I move the admission of Stacy Exhibit 3.
No objection.
It's admitted. Thank you.
Okay, nothing else.
All right. Counsel, I'll give you 6 minutes for redirect.
6 minutes.
I'll talk fast, Your Honor.
All right.
And I'll run up to the front. Good afternoon. My name is Kathy Nestor. I represent Mr. Robinson, Agent Hall. You certainly seem familiar with a lot of the evidence here. Is it fair to say you're one of the key case agents in this matter?
That's correct.
All right. And as one of the case agents in this matter, certainly it's up to you to look at every piece of evidence that could be important in this case. Is that right?
That's correct.
And as a matter of fact, if I understood your testimony correctly, you said that you guys put posters up asking students, if you have videos, please give them to us. Is that right?
I believe that the posters were asking if anybody wanted to provide a statement to us, that they would be encouraged to do so.
So you encouraged all the kids that were there and other people to come forward and give you a statement. Did you not?
I did not personally, no.
Your posters did.
The posters did, correct.
Okay. And you also put out a request for videos, if anybody had videos to present them to you. Did you not?
We asked if anybody had any information that would help us with our investigation, if they'd be willing to provide it to us. That's correct.
And it doesn't sound like you screened it. You were so like, if you have it, bring it to us, right?
I'm not sure what the question is.
You didn't screen for, well, we'll take your evidence, but we're not interested in your evidence. You took any evidence that came at you, right?
I guess the answer would be yes, because I can't screen it until I have it.
Exactly.
Okay.
Is there anybody that came forward and you said, yeah, we're really not interested in talking to you at all? We're not even going to take your statement?
I believe there were people who were pre-screened who wanted to provide information that didn't have any substantiated connection to the investigation.
But somebody connected with this investigation spoke to them and decided they didn't have any valuable information, correct?
Yeah, they documented their contact and then made that decision.
Okay. And the videos that you got, you understand that these videos have been used far and wide to look to see if there were potentially other shooters in the crowd. Have you seen this on social media? Thousands of them?
Again, I guess I don't know what the question is.
All right. Are you aware that the videos that have been taken from the scene have been analyzed by people on social media and in the press to see if there was somebody else that could have been involved in this? Are you aware of that?
I'm aware that everybody has a theory on the case. Yes.
Everybody has a theory on it, right?
Mm-hmm.
So wouldn't you think it would be fair to say that any video that was taken there that could one way or another address whether those theories are good or bad, or whether your theory is good or bad, you guys should at least take a look at them? Fair?
Yes.
All right. And you became aware that Mr. Grunander had a child that was present at the scene. Is that right?
That's correct.
And did you look at her videos?
I did, yes.
When did you look at her videos?
When I received them, when she was interviewed by Agent Mortensen.
So that would have been a couple weeks ago.
Correct.
All right. But when you were doing your investigation of this case initially, you never looked at her videos.
Ms. Grunander did not come forward as a witness, no.
And the Utah County Attorney's Office knew that she had been there, right?
I'm sorry?
The Utah County Attorney's Office knew she had been there that day?
At the event?
Yes.
Correct.
And they knew she had videos?
I don't know if they knew she had videos or not, but they knew she'd been at the event.
But they sure weren't forwarded to you, were they?
Not until last week, no.
Okay. When this came out and there was a motion filed in court?
Correct.
All right. And have you ever interviewed Mr. Grunander's adult child?
As I said, Agent Mortensen did that interview. I did not.
And that was done when?
Either a week or 10 days ago.
Right. And so up until about 10 days ago, you all did not look at her videos, right?
No.
You did not interview her?
No.
And the county attorneys knew that she had been there, right?
Correct.
And they knew she had videos?
Correct.
And were you told by anyone not to interview her?
No, I was
Were
not.
you told by anyone to leave her alone?
I was not.
You said the SBI collected over 40 statements. Is that right?
Correct.
And that's from people that were just in the audience?
The 40 that I mentioned is from people who were at the event, yes.
So people in the exact same situation that the prosecutor's daughter was in?
In terms of being at the event?
Yes.
Yes, people who were at the event.
And you thought they were worthy of taking statements from, right?
They came forward to give us statements, correct?
Because everybody's perspective is important.
If they're willing to share it, yes.
And as a matter of fact, you've gathered, as I understand it from today, I want to say around 300 terabytes of video information from the scene. Is that right?
I believe there's in the region of 248 terabytes of data from Utah Valley University alone.
And the adult child of Mr. Grunander is in the exact same position as everybody else who's given evidence in this case, isn't she?
In terms of being an attendee at the event?
Right?
Yes, she was an attendee.
And
at the
having
event.
video?
Yes.
And having witnessed things herself?
You'd have to refer to her testimony as to what she witnessed.
Okay. And you mentioned, I know I have 2 minutes. I'm going to talk very fast. I know she's about to kill me. You mentioned the DNA evidence. You're certainly not a DNA expert. Is that correct?
I'm not, no.
And are you aware that the DNA evidence that was seized from the scene consisted of a mixture of at least 5 different individuals?
I'm not a DNA expert, so.
So you know enough to say what helps him, but you're not going to answer whether or not there were 5 individuals mixed into that DNA.
I'm not aware of that, no.
Okay. And you're certainly not qualified to interpret complex DNA mixtures, are you?
No, I'm not.
Okay. Court's indulgence for just one moment, Your Honor.
She's a little pushy for me. It can get to the point of.
Ms. Nestor, is there, I know I gave you that 6 minutes. Is there any other questions that you feel you need to ask?
Thank you for asking, but I think I'm done. Thank you.
Thank you.
It gets annoying because
All right.
it's not reasonable.
That concludes the
framing.
taking of evidence, this portion of the hearing. We'll turn to closing arguments or arguments by the parties as it relates to this. May this witness step down.
Yes.
As much as he'd like to sit there indefinitely. We'll go ahead and excuse him. All right, counsel, we have, just before we begin, I note that we have a hearing set on the break for February 24th at 10:30 on WebEx. Does that comport with the agreement of the parties?
On what day, Your Honor? I'm sorry.
February 24th at 10:30 in the morning on WebEx?
Thank you, Your Honor.
Yes, Your Honor.
All right. And so it's the intent that the court will issue an oral ruling and a written ruling on that same day. And at that time, depending on how the court rules, will determine what we address next in regards to the motion regarding media in the courtroom. And so we'll take to that point. I do wish to state that this court's mind is not made up and that I would ask all parties to continue in their roles because the court has not issued a decision in regards to the disqualification of the Utah County Attorney's Office. So I would ask that all parties continue to move forward diligently as they have and have made a note of that. All right, so it's 4:37. My lawyer math, let's see. It looks like you would get 10 minutes each for your arguments, and we will end at 5. And if you want to reserve time, you certainly can do so, but take that into account when you're making your argument. Mr. Novak.
Thank you, Your Honor. Your Honor, there are legal issues and there are factual issues that we think that the court needs to look at very closely. I would ask the court, because I only have 10 minutes, to look at both the briefing in the original motion, and I will point out some specific cases that we think the court should pay attention to, as well as the briefing in the what I'm going to call the renewed request. And they're both informative. The briefing in the renewed request doesn't just go to the question of should this court encourage, that's the language that the statute hints at, the state attorney, the county attorney to refer this to the attorney general, but it also refers to when a trial court does or does not abuse its discretion with respect to recusal. The last witness, and I'm gonna just go with the principle of recency here. The last witness's primary purpose was to focus on this question of whether the adult child student at UVU is what the state has referred to as a material witness or a critical witness. And that is actually either intentionally or unintentionally a distraction from the real question here. This is not a question of whether, in order to prove its case, the state needs to call as a witness a family member of the prosecution, okay? That could, in another situation, be a source of a conflict. But the issue here is that the most experienced and most senior prosecutor in the office, other than the elected county attorney, Mr. Gray, should have been walled off from this prosecution until this court had an opportunity to consider whether disqualification is necessary.
That has to do with material witness standard, doesn't it? Oh,
it is important to note a couple things that Mr. Grunander said. One of them was that he'd never seen, in his experience, a decision to seek the death penalty made without regard to information about the accused. And there's a hint there that there was an emotional response to Mr. Kirk's death, which there's a strong implication creates an appearance of impropriety. And so this court doesn't have to make a finding that there's a conflict of interest, an actual conflict of interest. What the standard says, and that's the standard that Mr. Gray read into the record from the organization of Utah prosecutors that he's the president-elect of, which refers to the public perception of the integrity of the prosecutor's office and the public confidence in the handling of the case, okay? So that was standard 1.3-3C. The failure of Mr. Gray to at least temporarily wall off Mr. Grunander, to seek guidance from any other prosecutor, ethics expert, the court, the state bar, people who are leaders or members of SWAP,
Where's the law that says
the Attorney
they have
General's
to do any of those
office
things?
demonstrates both a very an inappropriately casual approach to this issue. And it also demonstrates that what Mr. Gray did is he put his need for Mr. Grunander to lead this case ahead of the ethical consideration of whether that might create an appearance of impropriety. Not an appearance in Mr. Gray's opinion, not an appearance in Mr. Grunander's opinion, but an appearance in the public eye. And that's actually your Honor's project, if I may, is to determine what a reasonable member of the public would think of this scenario. The other thing that is important here is that we are dealing with a proceeding where the Eighth Amendment to the United States Constitution and the parallel constitutional right in Utah require, and this court has heard it already, and the court's going to hear it over and over again, a heightened standard of reliability. This is not just a court proceeding, and it's not just a criminal proceeding. This is a capital proceeding, which is at this point in time sort of almost the only proceeding where the Eighth Amendment comes into play. And so this court needs to view the appearance of impropriety under this heightened standard of reliability. A couple Utah cases that I think that this court, we would ask this court to look at very closely. State v. McClellan, Utah Supreme Court, 2009, Utah 50. State v. Cater, C-A-T-E-R, 2014. I'm sorry, yeah, that's a Court of Appeal decision, 2014, Utah Appeals 207. Mr. Gray should have implemented a firewall, and he didn't. And that has created this problem. And then what we see is isolating Mr. Grunander's daughter from the investigation, isolating her in some way so that she hasn't provided a statement, she hasn't provided videos until we bring this issue to the court's attention.
Well, she had the choice, didn't she? You didn't prove anybody. You could have asked Grunander on the stand. Did you isolate her? And you didn't do that.
The decision as to what charges to file, the decision as to whether or not to seek the death penalty should never, ever have been made in consultation with Mr. Grunander, even if he's the most experienced homicide prosecutor in the office, even if he has one of the longest tenures, and even if it's Mr. Gray's ultimate decision. Because now we don't really know, and the court doesn't know, and the court just can't defer to the prosecution. That's the whole point of the court having the supervisory power over this issue. What influenced Mr. Gray? I would also point out that Mr. Gray did not disclose until asked, while under oath, that two members of his faith community were also present there.
Oh, Lord.
That was not disclosed to us when he found out about it. And that he has a relationship with the family of some young person who was also negatively impacted. This line of sight analysis, this PIE that has been diagrammed is not the question. That is not the question. The question is whether Mr. Gray should have isolated the prosecutor whose child was there, and I say this with all due concern and respect, could have been injured in any number of ways. People could have been hurt leaving the scene. And I'm not saying that in any way to minimize the effect that that experience had on Mr. Grunander and his family.
So if the jury finds
I think, as I
Mr.
said
Robinson did it, is that going to be
court
helpful?
last time, I've been through this where I learned that
people.
my child is somewhere where there was a shooting. And until I knew my child was safe, that was, an overwhelming emotional experience. So the problem is that Mr. Gray approached this in an incredibly casual way. There isn't a single memorandum, he testified to this, documenting the process of whether there's an actual conflict or an appearance of conflict.
Oh, this poor guy. I feel kind of bad for Mr. Novak.
The mere disclosure of it to us and us bringing it to the court does not wash this clean. That is our concern.
He's doing the best he can with really bad material to work with.
I also want to cite the court, because I'm running out of time.
Garbage in, garbage out.
To a decision that is not a Utah decision, but it's cited on page 12 of our motion, which is Tate, 925 Southwest 2nd, 548, a Tennessee decision, where basically the court says where there were no screening procedures and the prosecutor, as to whom there was an appearance of impropriety, maintained the role of a supervisor, and there was open discussion of the case with him, there should have been a disqualification, and what the court did there is it disqualified the entire office. So this problem could have been avoided if Mr. Grunander had been screened off, if Mr. Gray had sought this court's guidance early. The state, they were in court on September 16th. This could have been brought to the court's attention in September. Counsel were appointed shortly thereafter. We could have addressed this a long time ago. And now, frankly, it's too late. So we understand that there is pressure on the judicial system to move this case expeditiously. There is also a countervailing, and we believe, stronger need to make sure that there's a heightened standard of reliability, that there is no conflict, and that there is no appearance of conflict. And if that takes a little bit of time for another prosecution office to get up to speed, the investigation is going to continue, the discovery production is going to continue, the lab work is going to continue, none of that is going to change. So we would ask the court, I'm not reserving any time in rebuttal, I'm going to ask the court to grant the motion.
You've gone over.
Both parts of it, which is to make a finding that Mr. Grunander should have been walled off and that Mr. Gray's failure to do so and sort of the casual way that Mr. Gray approached this whole thing requires, unfortunately, the disqualification of his office and the appointment of a new group of prosecutors to be responsible for this case. The case will continue. What we are asking the court to do today does not in any way change the fact that Mr. Robinson is charged. He's charged with an aggravated homicide. We all have to deal with that, but we have to deal with it in a way where there is no question that the decisions that have been made or decisions that will be made in the future, which is some questions that were brought up to Mr. Gray by his own counsel, and the public's confidence in the outcome of this case are tainted by what should have happened and did not happen. And I appreciate the court's time.
Thank you, Mr. Novak. To the state, looks like Mr. Novak took 13 minutes.
I'll pay you back later.
Thank you. To the state, I will afford you that same time frame. If you want to take all 13 less, I'll leave it to you.
I know everybody in here is going to blame me if they don't leave in 9, which is 5 o'clock. So the reality is, Your Honor, the adult child is not a witness here. She didn't see Charlie Kirk get shot. She didn't record him get shot. She didn't see his wound. She didn't see him get carried off. She's just not a witness. And as a result, there's really no conflict here. Now, I understand that conflicts go beyond just that, but most of the cases that we look at where there's some kind of conflict are where there's confidential knowledge that has been obtained by the prosecutor, right? A defense attorney becomes a prosecutor and now has confidential knowledge about that person, right? That's the typical conflict we see. Has some kind of proprietary or financial interest, right? That's the kind of conflict we usually see. Occasionally there are personal conflicts, but there's a lot of good case law that talks about what kind of conflicts constitute that personal interest. And I think the best case law on this is cited in our opposition to the renewed motion to refer the matter. And in that case, State v. Newman, the court found, this is a Missouri case, the court found no conflict of interest in prosecuting a defendant for murder, even though the prosecutor had done business with the victim, knew him personally, and served as a pallbearer at the victim's funeral. In the Gwinnett County District Attorney, nor his Georgia office had a conflict of interest, even though his chief investigator dated and later married the victim in a case that the office was prosecuting. In Kansas, prosecutor's office did not have a conflict, even though the defendant threatened to blow up the very courthouse and also housed the district attorney's office. I mean, these are cases where the prosecutor has a close relationship with the actual victim of the crime. Look, if Mr. Grunander were related to Charlie Kirk, we would acknowledge there's a conflict here, right? But we're not even close to that. The adult child is not even a witness in this case, is not a witness to the murder. Is the child a witness to the circumstances? Sure, but so are 3,000 others, as well as dozens of video recordings. She's not a witness. She's not necessary in this case. And as a result, there's no conflict here. Now, is he going to be motivated because she was present? Is he somehow going to be motivated to do something he otherwise would not? Well, again, maybe if she were injured, maybe so. Maybe there would be a good argument there. Maybe it still doesn't rise to the level of these cases that I've talked about, but that's just not the fact. She has not been traumatized. She has not had to seek therapy. She has not had to miss class. It's not affected her friendships. As a result, the idea that Mr. Grunander is going to be motivated by some kind of retribution for what happened to her is just flatly false. The idea that the defendant was charged for killing someone because a prosecutor's child was present when it happened is just, it's almost laughable. He's being prosecuted for killing someone because he killed someone. At least that's what the evidence will show, we believe.
Well,
the idea that he has
I
been,
hope you
the
believe
death
that.
penalty has been elected because a relation of a prosecutor was there is just laughable. It's because someone was shot and killed. That's why the charges were brought. I just don't think that proposition is palatable at all. The evidence is what this case was charged on, both at the charging level and at the death penalty level. None of this was motivated because of some relationship. And I think that anybody who looked at this would agree that you don't charge someone with murder because a witness was affected by it. You charge someone with murder because someone was killed, right? The standard. The defense has tried to elevate the standard here by looking at best practices, the SWAP's Statewide Association of Prosecutors best practice. Even so, I think it's been misstated. The standard says that when there's an appearance of conflict, the prosecutor should, I quote, consider recusal. Well, that's the question. They should consider it, right? It doesn't say it mandates recusal or disqualification. And that's not even the ethical standard that this court goes by. That's the best practice. And the best practice was followed in this case because once that fact was known, there was a discussion. Of course, it was disclosed immediately. It was disclosed 5 days after defense counsel was appointed. The idea that the child was isolated is just flatly false. She just was not a witness. And the follow-up with her showed as much. The standard is there a significant risk that representation of the state will be materially limited by a personal interest of the lawyer? In this case, the decision to prosecute and the prosecution of this case will not be limited in any way. Moreover, if anything, the interests would align. Regardless, the motivation here is clearly not because of the presence of this child, it's because Charlie Kirk was murdered in front of everybody. She's not a material witness. Everybody knows Charlie Kirk was shot and killed and murdered brutally. Everybody knows that. I don't think that's going to be what this case is about. It's going to be about identity. And neither the child nor any of the other 3,000 witnesses present really have a whole lot to say about who this was that did the shooting. And that's what this case hinges on.
For most people. Most people are not contesting that Charlie Kirk.
There's been no evidence that Prosecutor A's child had any effect on the prosecution of this case to date. And there's no reason to believe it will have any effect in the future. The testimony was clear that no one anticipated that based on her lack of value as a witness and the lack of trauma or injury to her, there really shouldn't be any question about that for this court, for the public, or anyone else. Thank you.
Thank you. Thank you to all parties. I acknowledge the hard work and effort that went into today, and this court appreciates that. We will reconvene on February 24th at 10:30 in the morning via WebEx. And just for clarification to defense, in regards to Mr. Robinson, how would you like Mr. Robinson to be present at that hearing?
Your Honor, Mr. Robinson, I believe it's WebEx for everyone, right?
It is.
He can also be on WebEx. Your Honor, we would waive personal appearance for that.
All right. Thank you. All right. With the new date set.
Wait, I'm sorry, just a minute. Audio. Oh, sorry. Audio only. Thank you for my co-counsel. Audio only. No screen.
All right. I appreciate that clarification.
Thank you, Your Honor.
And with that, court is in recess.
All right. That's it. Well,
10:30.
Well. Some interesting little tidbits came out of that, huh? Well, so, we talked a lot about the law of the conflict of interest going into the last hearing, and there's nothing that we heard that's elicited that's significantly different than what was already in the motion. And based on that, I don't think there's any chance this motion is being granted. The law is very clear. If it's a material witness, that there's some type of a personal conflict that is in misalignment with the prosecutor's general interest to represent the public as a whole in pursuing the case, then disqualification is warranted. But short of that, it's not going to be required. And the separation of powers interests that the prosecution has pointed to, where this is the person that has been elected by the people of Utah County to pursue exactly these types of decisions, for a judge to come in and interfere with that part of the democratic process, they need to have a justification to do that. And so falling short of establishing that the witness is material and so therefore likely to be called, right? Because you can imagine a situation where the witness is called and, is going to be cross-examined, going to be impeached or something like that. A guy's not going to impeach his own daughter, make her look like, she lacks all credibility and things like that. So in that type of a situation, yeah, you got a risk of a potential conflict. But if she's not a material witness, then that likelihood is extremely low to none, because there's no good faith reason to call her if she doesn't have anything to add beyond what 2,999 other people could say about the case, and frankly, potentially less than a lot of those people would have to say about the case. So when we came back, they had closed the hearing for the daughter, but did not close the hearing for Chad Grunander. We now know is Prosecutor A. We now know officially, I should say, that Chad Grunander is Prosecutor A. It was his daughter. He was such a better witness than Jeff Gray. Jeff Gray is too much of a politician. He wants to talk too much. He wants to say too many things. He volunteers too much. Grunander is sharp. He was able to spot right away where the question is going, but give his tailored response, and just give that, not do that thing that Jeff Gray was doing, where he just kind of wanted to add one more thing and add another thing, and it's like such a terrible thing for a witness to do. Every lawyer always, the first thing you prep your witnesses on is just answer the question. Don't answer anything beyond the question. as far as like the details, it's nothing we don't already know. Daughter texted him. He was at the thing. He found out nearly immediately, like within 10 minutes, that that she was okay. She had gotten away. And so went down to the scene and helped at the command center, and they were dealing with George Zen at that point in time and all of that kind of stuff. Yeah, I bet it was pretty chaotic. Found her bag, identified her bag, and according to him, that is just the extent of her presence playing a role in what he did at the scene. Now, why is this important? Why does it matter? Because this is the homicide guy. Okay, this is the death penalty case, and this is their best guy. So of course the prosecutors want him on, and of course the defense wants him off. Of course they want this guy off. They want this case to have to be run, at best by some inferior prosecutor, some junior prosecutor, that they can try to, run circles around. That isn't going to have the sophistication and the experience that the main homicide prosecutor who does the death penalty cases. He's lead counsel in the Jane case that's going on right now. Now he said one thing interesting. Now this gets to kind of maybe what was the point of this all, because like I said, extremely low likelihood that this is getting granted, in my opinion. The evidence has been kind of a waste of time in the sense that it really didn't elicit, the fishing expedition didn't work in terms of getting them some surprise facts that were particularly helpful. The judge is not going to care about random people that go to church with the prosecuting attorney. It doesn't matter. Guys, prosecutors exist in small towns, and so do judges. And they're not required to be social outcasts. Okay. They don't have to move themselves into the prosecution equivalent of a leper colony in order to do their jobs. They're allowed to have relationships, and those types of things are fine. The issue is only when the personal interest creates a type of relationship that potentially puts the prosecutor's interest in that person in conflict with their duty to evaluate the facts, evaluate the evidence, make decisions based on those types of considerations. I had somebody bring up a situation to me not long ago that I think might highlight this this type like just the difference with this type of situation. And that was a situation where a prosecutor was having an extramarital affair with the victim in the case. And this person was apparently told what people are often told in situations where, like, the prosecutor knows somebody or something like that, which is that the prosecutor is allowed to have a bad opinion about the defendant. That is in alignment with the prosecutor's interests. If they think you're guilty, they're supposed to think you're guilty. Like, that means the prosecution is working the way that it's supposed to do. So the problems come up when there is something that is threatening to distort their perception and their ability to be able to substantiate that. And so in a situation when you're having an extramarital affair with the victim, okay, this is problematic in multiple ways because, number one, the victim is a material witness, okay? So that victim is going to get on the stand, and that victim is potentially subject to impeachment and cross-examination and so forth. As a prosecutor, you have a duty to disclose impeaching evidence about your victim, your witness in the case. And the nature of your relationship in and of itself is the kind of thing that's potentially impeaching, right? Because you're hiding it for a reason, and it goes to the potential bias that the prosecution and the investigators may have when they are reviewing that witness's testimony and their position and so forth. And that's the type of thing that defense lawyers get to bring out during cross-examination, is that a victim is biased. Why are you biased? Because you got this relationship with the prosecutor that, by the way, he doesn't want anybody to know about. So that's the kind of situation that is, in my opinion, aside from the financial conflict kind of scene that he talked about, or that I was the lawyer on the case before, or something like that. This is a personal conflict where, yeah, to me, that one is pretty obvious that prosecutor needs to get out. But this is nowhere. This is just nowhere near that, because they haven't shown anything that suggests the nature of this relationship prevents any, it poses any kind of bias because she's not material. And so, like, you have 3,000 other people that not only can you rely on, but you're kind of going to rely on, like you have relied on in the course of conducting this investigation. So, yeah, extremely low probability, in my view, that this motion is going anywhere. From a fact standpoint, largely not really anything accomplished. However, there's reasons why defense lawyers want to do things like this anyway. Defense lawyers always want to have pretrial evidentiary hearings, and that's why you'll often see like motions to suppress evidence that are extremely marginal, extremely thin, like little to no basis. Nobody really expects them to win. Why are they doing that? Because they want to get people under oath early, and they want to get facts on the record early. And then those facts are now kind of part of the case because you're stuck with them. You've testified to them. And there were some facts here. There's one particular statement during Chad Grunander's testimony that I put a little star by, because I'm like, ooh, I wonder if this is going to come back to bite them. Because he talked about how the death penalty decision was made probably the second or third day after the event. And Jeff Gray, you used to call him Jeff, which is fine. Jeff had made the statement, or he had communicated to the team that he intended to do it if they have the facts to support it. If they have the facts to support it. Well, that's kind of backwards, isn't it? That's kind of the other way from what Mr. Gray suggested his thought process was. If we have the facts, I'll support it. But this is saying, I'll do it as long as. So you've kind of already made the decision that you want to go down this road. And this is not shocking at all to me. I would kind of expect that as a practical matter. This was a high profile case. It got a massive amount of attention. You had people all the way up to the President of the United States saying, gee, I hope this one gets death. I feel like there's a concession in here that they already knew they were going to pursue the death penalty as long as they could find some kind of hook to support it. And so that's why, we're relying on this relatively tenuous, not impossible. It's not completely ungrounded in any sort of theory, but it's the endangering other people with one shot that hit the target. It's a little bit of a stretch. And so the reason why that might matter is because, we can fully expect the defense is going to take every single opportunity they can to try to take death off of the table. And what are they going to point to? Well, probably their other target here, which is the media. The media. They're going to potentially be able to use this to feed into an argument that, the media coverage has been prejudicial. And one way in which it's done that is because it made it so high profile. And because of that, the prosecuting attorney decided he wanted to pursue the death penalty before he even knew if they would have the facts to do it. Kind of wonder if that was a little bit of a giveaway in there that might be something they can capitalize on later on. So that's why they do it anyway. Even if they're going to lose, even if they don't expect to win, That's why they do it anyway, because they might get stuff that they can potentially rely on in some other context. So not really anything else that I saw that was particularly intriguing from Mr. Grunander's testimony. It was nothing. It was just what we already knew from the motion, more or less. I just noticed. I noticed his demeanor. You know, the way that he handled certain kinds of questions. The way that there was a question right off the bat about you know, implying that the fact that you thought this was necessary to disclose, and he just bing he was right on that. Okay, he already knows where this is going. Okay, because you don't get to be the head homicide prosecutor in your office by being slow about what's the question behind the question. He knows what's coming, and he got right out ahead of it. Don't take that as a concession that we thought there was anything to this on the merits, that we thought this was anything less than frivolous. This was us acting in an abundance of caution, trying to be professionals, trying to have integrity. That's why we decided it was worth disclosing, even though we decided it wasn't a particular problem. So just caught him like, he's on you. He's on you, Mr. Burt. He knows exactly where you're going. The zone of danger issue, like that's what we know is what relates to the decision to seek the death penalty, and whether or not they can establish minimum facts to show that other people were in the zone of danger by the single gunshot. So again, it's like, yeah, they'll meet the low bar of there being sufficient evidence to do it, but is it like the best case ever of endangering others? Definitely not. It's just a situation where I could see a jury that isn't necessarily like super inclined to vote for death. You know, potentially not being real enthusiastic about this basis for it. So then we got the state's witness, David Hull, who we have no idea where he's from. I was leaning towards South Africa. I don't know. It's an interesting accent. It seems to have like, it just little bits and pieces that this part sounds English, this part sounds Australian, this part sounds American. It could just be mixed. I don't know, but he's got some kind of interesting provenance. And so his primary job was to talk about how he was doing the investigation. He was not receiving direction from the prosecuting attorney's office about how to do that. You know, he wasn't basing any of those decisions based on Grunander or his daughter. They just got what they got. And then we got the evidence. So they didn't put those videos into evidence. Interesting. Very, very interesting. The ones that we had heard about, 4.1 was the one the defense had objected to. That seems to be the one that was everywhere the day Charlie Kirk was shot, all over social media. But then the second one was 5.1, which is the one that was taken from TPUSA's camera. It was taken from the back and showed the speaker out in front of Charlie Kirk at the time that Charlie Kirk was shot. Just put screenshots from those videos into evidence. And the reason why is because they were really just showing the context. They wanted to show here's who's nearby for purposes of establishing this is the evidence we had about who was in the zone of danger, and this is not Chad Grunander's daughter. So what they did put in is yes, potentially now public record. They didn't seal it, nothing like that. So I would fully expect these things can be and probably will be requested and obtained by the public, although we'll have to see. But they left out those two videos, so they are no longer in evidence. Or I shouldn't say no longer, but they didn't make it into evidence because they weren't offered. Then we got a little kind of summary of what some of the other evidence was that led them to identify their suspect. They had surveillance footage from UVU. They had doorbell cameras from around UVU, also in St. George, also in areas in between. Video footage from businesses in Orem, in St. George, and in between. Text messages from associates of Tyler Robinson that indicated he had been involved in the incident, as well as social media chats. Wasn't clear if they were talking about the same thing or a different thing, because a social media chat, I don't consider the same thing as a text message, but if they're using shorthand, it's kind of hard to say. I don't think we know the as far as the communications with Lance Twiggs go. I don't believe it said in the probable cause affidavit, like specifically what those were, or what, if they were SMS messages, if they were on Discord, what exactly the details were. I suppose I can check real quick. So I do have all the legal documents. Let me just double check. Anyway, so possibly that this is referring to something different than what we already know about, but not entirely clear, because that language can be a little bit ambiguous. Text message, social media chat, not entirely clear. CSI evidence, DNA from the screwdriver on the rooftop, as well as the firearm. They did a search warrant at his house. They obtained additional bullet casings that had engravings on them. Wonder what they will say. Tools for doing the engravings, targets that had been purchased recently, Ring doorbell footage from there, and laptops and such, which is kind of what I knew was going to be coming, and where I expect there's going to be a lot of interest in the digital footprint. I mean, that's just kind of the bottom line. They're going to be tracing his location, and that's where I was getting at some point. Had to cut off my thought as they were coming back into court. I think we were talking about the 30 days of UVU surveillance footage, and the issue is going to be they are going to be comparing that to Tyler Robinson's location data. And they're going to be looking to see, oh, here's a person, on the roof or whatever, 3 days before. Is Tyler Robinson there based on his phone data? You would expect those things to correspond, unless he didn't have his phone with him, which is, certainly possible, but not usually what somebody does when they drive several hours from home to a place I don't I guess have any reason to know if he's already familiar with UVU campus or not. So it's going to be the tendency of those pieces of evidence to corroborate each other. That is what gives them weight. If you can find other people like around or in the area or something like that, might help. But if everything from Tyler Robinson's digital data lines up with the person on the roof at the Low C Center and the person that's, walking to campus and so on and so forth, they're going to have a pretty good case for those being the same people. And part of the question is just going to be how precise of location data are they able to get. If they just have cell site data, it might not be that precise. But if he's got his location services turned on and they can get GPS data, that can be very precise. That is very likely going to put him, on the roof within a few feet or so. Not uncommon for GPS data to be that precise. So that's what we're really going to be looking for, at least what I'm going to be looking for in terms of how incriminating is that. Of course, they found the firearm, etc. So little preview there. Then when it came up on cross-examination by Kathy Nestor, she's quite aggressive, isn't she? And the thing is that it's a great gear to have. It's like it's an essential gear to have as a defense attorney, to be able to get up in somebody's face and call them out. It's just that you can't be your only gear, or it loses its effectiveness. It's just like the risk of diluting, bringing up Tyler Robinson's right to a fair trial every single time you have something to say. Arguing you want something. Like every time recently they've been filing something under seal, it's just been based on this kind of generic right to a fair trial, which nobody disagrees with him having the right to a fair trial. It's just that you need to establish specifically how it's undermined by what you're trying to file or what's being proposed. And it's a little bit, can be a little bit harder to do. So just notice her gear is quite aggro. The witness, I think, handled that extremely well. I'm sure he's practiced at doing that kind of thing. He just remains calm and then ends up looking like the reasonable person in the room. That's the risk of having strident as kind of your only speed. But she did bring up something that was potentially interesting. Did you know that DNA was a mixture of at least 5 people? The DNA from the scene, a mixture of at least 5 people. He says he's not aware of that. Oh, so you can bring it out when it's beneficial to them. But, well, he just read the report is pretty much what he was asked about. So, but the mixture of 5 people, don't know which sample we're talking about here. DNA from the scene. From the scene. Is this the screwdriver that was on the roof? Might be. A mixture of 5 definitely presents some issues in terms of interpreting it. A lot of places won't interpret a sample that's 5 or more, or potentially even 5. Because it starts to get a little bit too complicated statistically. The problem is that the more contributors you have, the lower statistical strength your match is able to have. And it's just because it gets harder and harder to sort out who contributed what parts of the genome when you have these many options. So that's at least with conventional STR technology, which I have no reason to think this is anything but that at this point. So we'll see. Mixtures can have major and minor contributors. Could be a situation where they're like, yeah, Tyler Robinson is the 99%, contributor. Could be Tyler Robinson is the 51% contributor. It's just, we're not really going to know until we get more information about that in terms of like how strong of a conclusion is this really? Like how certain can we be that this is in fact Tyler Robinson and not just a soup of a bunch of people that if you pick out the right pieces, you can make it look like him. Yeah. 5 from the scene. Is the scene the gun? Is it both? I mean, don't know, but the mixture is definitely intriguing. So the closings, yeah, I gotta say, I'm not super impressed with Mr. Novak. I appreciate the position he's in. I really do. And I don't want to minimize it as garbage in, garbage out, but it kind of is, when you don't have a lot to work with, you don't have a good factual case here for a conflict of interest. And so you got to come up with something though. And, he tried to he tried to suggest like the standard, which under the case law is this person a material witness, is somehow a distraction. The real issue is like procedural, and it's just this very circular, it's this begging the question type of suggestion that Jeff Gray needed to assume that there was a conflict for purposes of screening off Chad Grunander until they could go through this, I guess, or just whatever process to determine there's a conflict, and then go with that. It's really the same argument that they made from the outset about the attorney general needing to be the one handling this motion, and the judge is like, yeah, we're we're not going to make that assumption that there's a problem here, you know, on the showing that was made so far. He tweaked that ruling a little bit today. He just basically said he doesn't think the facts implicate any kind of like, they don't have enough resources, they don't have enough staff, they don't have the ability to litigate the motion. So he kind of took it out of the framework of the merits of the claim that he had relied on last time, where they focused on, like, is there a preliminary showing that needs to be made? And I don't think you've made it. He got away from that this time. He basically said, I think the statute is talking about a different type of situation, and there's no showing that that situation is made here. But bottom line is that's really what the defense has, is the circular argument that you have to assume a conflict, even though factually they don't seem to be in any kind of a position to establish that disqualification is required. And so because of that, the question to me ends up being, so what's the problem? Okay. You're almost always dealing with harmless error in situations where you're litigating process. They did the wrong process. Okay. What was the result of that? Does it have any meaningful effect on the outcome? And if it didn't, then they don't care. The court doesn't care. It's not a structural error to have an unconflicted prosecutor stay on the case, even though you think they should have followed a different procedure to evaluate it. But you know, they don't have good facts. And so you got to come up with something. And that's what he comes up with. Focus on the process. The 8th Amendment means, you know, it's death. Death is different. So you need to kind of heighten the standard. He did, I think, you lose credibility when you have to stretch the facts and stuff, you know, isolating her from the investigation. That was not established whatsoever. Made it very clear. She chose not to come forward. And you had Grunander on the stand. You could have asked him, did you ever tell her not to? You could have elicited that and you didn't. And so the fact that you don't and then kind of pretend that you did, to me, this is always a little bit of a problem when it comes to the reliability that you have with the judge. The judge needs to be able to count on you to be fair. And so when you pull things like this, they're little signposts to the judge. You risk that he's going to file that away and remember, oh yeah, I remember when that time when that guy exaggerated about the prosecution isolating the daughter from the investigation, and that didn't happen at all. So now when he's telling me something that sounds really bad happened, I don't know if I can believe it or not. Don't know if I can rely on his representation. State's response, you know, pretty straightforward. This isn't an issue because she's not a material witness. That does seem to be the position that the law supports. And so in light of that, I think it's highly likely this motion is going to be highly likely it's going to be denied, but we will find out for sure February 24th at 10:30 on WebEx. And so that is where we are at this point. Let's see what you guys have to say. I did star a few comments as we went through. Nicolaire 3352. I don't know how I get so lucky every time there's a TR hearing. I get off work and Andrea is on. Thank you. I don't like to miss the Tyler Robinson hearings if I don't have to. This is one that has a lot of eyes on it. A lot of as came out during the testimony. Everyone's got a theory. And, you know, it's a free country. Everyone is certainly entitled to have a theory. But I like to watch the evidence. I like to see what comes out during these processes and not assume that I know more than I do. So I do like to be here for that. The Ghost 4282, the comments from the prosecution saying 30 days of video before the shooting tells me they have him practicing. They might. It tells me this is what they're looking for. They're looking for planning and preparation. So who knows how far in advance? 30 days is frankly probably just the limit of what UVU retains. A 30-day period for retaining your surveillance footage is pretty common because it takes up a massive amount of data space. And so most people don't typically keep it forever. You overwrite it after a certain amount of time so that you don't have to, have your own private server warehouse just to store your video footage. But they're definitely looking for it, and don't know if they have it or not. They might. Kind of was implied, I think, perhaps by Mr. Hull that there's some useful stuff in there. But the defense is going to be looking through it as well. They're going to be looking for, evidence that doesn't correlate with Mr. Robinson's digital data and so forth. They're going to look for other things that they might be able to, identify as potential suspects or things like that. So until all of that gets vetted, of course, we don't know what it's going to be, but this is absolutely what they were looking for sure. Gingerpuff 764. So ruling on media in courtroom going forward will come via WebEx. No video of Tyler at all, except from rear of courtroom. Still photography allowed. Yeah, what he's done is he is not quite the full Koberger treatment for the cameras not being able to follow the rules, right? Koberger, they just yanked them all together and said, you can rely on the video court system that we already have and we use. And the result of that is that you only get fixed, close-up focus views on certain participants. And when you're looking back at the counsel table and the audience and stuff, it's just a wide view. And so it prevents them from being able to zoom in and fixate on the defendant. The conversations at table and so forth, these things that the court has agreed are potentially problematic to the right to a fair trial. The still camera, they've said, still camera hasn't violated the decorum order. So there's no basis for sanctioning the still photographer. But that said, they're still going to position him in an area where he's not a distraction and not a problem. In this case, it sounded like it was behind the bar, which tends to mean behind where the parties were sitting. So, the ability to capture a whole lot of close-up, full face shots are going to be limited. It's going to be, profile when he turns his head and that type of a thing. Ruling on media in the courtroom. What I thought I heard him say was that they will address the scheduling of that at the next hearing. But he might have said, because we didn't get a good, when they were kind of coming in and out of court, it was rather abrupt and they were, already doing things because the decorum order says they have to do it that way. He might have been saying it had already been set for this date for that ruling. So we'll see if there's there's likely to be a written notice of hearing that ends up on the court docket that just kind of substantiates that a hearing has been set and potentially, identifying what decisions are going to be announced at that time. So I will keep an eye open for that so we can get some clarity on the media motions. Christy CC, why does one man get to decide on seeking the death penalty? Because we have elected him to do that. That is the responsibility that the elected prosecutor has. That's what we elect him for, to be able to make those types of discretionary decisions. Seeking the death penalty or not is a discretionary decision, just like, hey, this case is chargeable, but it's so de minimis, don't think it would be fair to charge it, kind of thing. Those are prosecutorial discretion types of decisions, and how a prosecutor exercises their discretion is one of the reasons for choosing that person to be your representative over somebody else. So that's why it's discretionary, and he's the one elected to make the call. He gives beauty for ashes. Pardon me if this is a dumb question. I've not been following. What is the conflict? Don't all prosecutors think the defendant is guilty? Aren't the only people who need to be unbiased is judge and jury? I brought this up. I already kind of talked about this a little bit, just in terms of the idea that the conflict needs to put the prosecutor's interest in the job of the prosecutor to fairly evaluate the evidence and, determine that there's probable cause and only proceed, in the interests of justice and so forth. The conflict needs to not be a problem with that. And so, yeah, a lot of times it's not. A lot of times it's not going to be in conflict with that. If they just happen to know somebody who has a collateral involvement in the case or something like that. I mean, it's routine that prosecutors have relationships with the same investigators that handle the cases, that are their witnesses in cases all the time. It's routine and it's understood. And the same thing happens in the courtroom. The same prosecutors and the same defense attorneys appear in front of the judge all the time. And so it's to be expected that you have feelings about them and opinions about them. You will think this one's a good lawyer, that one's not so good a lawyer. The question is, does it reach a point where that's going to distort your perspective? You aren't going to be like open and receptive to what's actually happening. It's the difference between being informed and being biased. People are allowed to have informed opinions, even jurors that are going to be seated in the case. Knowing something about the case doesn't make you unqualified to be a juror. And even having an opinion about what you know about the case doesn't make you unqualified to be a juror. What makes you unqualified to be a juror is if your opinion is fixed, if you are unwilling to change it, if you are not going to be able to let go of that assumption, that opinion that you've developed in light of what is presented at trial. And so that's the difference between being informed and being biased. Biased is I'm so fixed, I'm going to reject, I'm going to reject stuff that's prevented so I can hold on to what I've already decided. So that's kind of the nature. It's related to the nature of the difference here. It's not disqualifying to have relationships with other people. But if the relationship is such that it prevents a problem for you being able to handle the situation and do your duty, that's when it becomes an issue. It's always a little bit easier, I think, to look at conflict situations with the defense lawyer, just because the defense lawyer's loyalties are so clear. With the prosecuting attorneys, it's more nebulous. They don't have a client. The entire public, the public interest, the goodwill of the community, is their client. But you can kind of get the same idea through situations where, like, okay, if a defense lawyer is representing somebody and you're in a small community, okay, always take yourself, put this into a small community, because it creates different contexts than you have in a big urban environment where they will routinely just like kick people off because you have a gazillion other lawyers that can handle the case and it's not that big a deal. A community that has 3 defense lawyers, for example, they have to manage these issues with conflict a little bit, closer to the gray area. And so a situation where I'm representing the client and one of the state's witnesses is my next door neighbor. Is that a disqualifying conflict? It simply is going to come down to, am I going to be unable to adequately cross-examine this neighbor in light of what the evidence is in the case, in light of, what value there is, what impeachment information do I have, and so forth. Am I going to be able to do that job under these circumstances, or am I going to be inclined to preserve that relationship? With something like a neighbor, you got other neighbors. It's like, how close are you to your neighbor? If your neighbor is also a friend, maybe you hang out all the time, it's getting to be a little bit of a different situation then. So it's very context dependent. It's not always easy to sort out the ins and outs of conflicts of interest. But so no, the prosecutor, they're expected to think that the defendant is guilty. And so just the fact that they have a relationship with somebody who like also thinks the defendant is guilty or, has some special insight into the defendant being guilty is not in and of itself a problem. The problem is it going to affect their judgment in light of all of the circumstances that are present? And so it could be very different, could be a very different question if the witness is, pretty much unimpeachable and uncontroversial versus there's like a lot of dirt on this defendant or on this witness and a lot of reasons why you might be disinclined to either, maybe turn that over to the defense or reconsider how you conduct your case in light of that. Not easy questions, but this one, having said all that, I really don't think this one is particularly close. Don't be hating one. A video of him walking in, not sure how that helps prosecution. The reason why they're bringing up all of this video and screenshot evidence and stuff that they showed was simply because they are setting they're establishing the environment. Here's what the situation was. Here was the format. This video likely gave them a view of the location so that you could see, here's the different places, here's the amphitheater and stuff like that. So it's all just by way of background at this point. Same thing with the screenshots of like, from the front, from the back, when the shot was taken. Here are the people that are in the zone of danger. That's really all that was for. Bass player 2001ify. IFY. Now I know they want media out. The guy is terrible. Oh, poor Mr. Novak. I really do think it's garbage in, garbage out. These guys are not slouches, okay? They're not bad lawyers. He's clearly an extremely smart guy and possibly a little too smart for his own good because he's able to think himself into these convoluted positions, that when you untangle them are not really there, but that's what he's got to work with, Defense lawyer is not a magician. I have said this so many times to so many people. The defense lawyer is not a magician. They cannot change what the state's evidence is going to be. They cannot change, what the defendant may or may not have done in terms of incriminating things, statements to police, etc. Their job is to work with the case that's presented and do what they can to, develop their own position. But you don't always have a lot to work with. A lot of times you get a case and your client is guilty 10 ways from Sunday. And so what do you have to work with? Well, you can, nibble around the edges of, maybe it should be a less egregious charge, or maybe we should do a special sentencing alternative or something like that. Sometimes, depending on your client, you might end up with, well, just roll the dice anyway and go to trial because anything can happen in trial. Trial can be a surprise to anybody. Witnesses don't show up. Witnesses say strange things. Roll the dice, see if you get lucky and something goes sideways and you get off. But if you don't, then what? Then you got a super guilty client who's been convicted by the jury and they're going to get sentenced and so forth. You don't always have a lot to work with. And that's especially the case when you're assigned. These guys, Tyler Robinson didn't go out and hire these specific people. They're his public defenders. They've been assigned to the case. So they didn't screen it for, am I going to be able to win this and increase my profile by having a big win, versus am I going to look bad if I, take a bunch of money to represent this guy and then I can't do anything for him? It's very different considerations that go into being a public defender versus being a private defense lawyer. So, he's a little, I think he's a little too smart for his own good, frankly. It's just my read on him. He's very intelligent, and it has the potential to like run ahead of his articulation and potentially get him in a little bit of trouble that way. We had Two Truth for Liberty joining us as a member. Thank you so much. Glad to have you with us. Pantoufle 10, Andrea, why do lawyers argue one element of a case so much with so little to work with versus focusing on more important elements of defense? More money? It's hard to say. Certainly money can be a part of it. I don't know the details of these guys' contract. I'm actually a little bit curious because I did see recently a media report. Somebody had gotten a hold of the contract and had reported some details about it. But I would kind of like to see it for myself just to see how it's structured. The things that were reported raised a little bit of red flags for me. So it's indicated it set the hourly rate at $295 an hour, which is not particularly high by national standards, but by Utah standards, I don't know. It doesn't seem extraordinarily low. But there was some details reported that were a little bit concerning to me that involved things like, basically, that is inclusive of everything. That isn't just the lawyer time. That also includes the travel. That also includes expert expenses, investigators, stuff like that. If they have to pay that out of $295 an hour, well, now your hourly has gone way, 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 way down. And this is a little bit troubling to me. So I would love to see the contract for myself and see how that's structured. But so, yes, it could be a situation where like, look, we're not making much hourly off this case, so we need to get in as many hours as possible. I mean, just because you're appointed doesn't mean you're exempt from needing to be able to pay your bills. These are contract counsel. It's not like there's a public defender's office that is paying for all of the overhead and things like that. So they've got to find a way to make this work. And the incentives... The incentives are there. Financial incentives are always kind of there. So that could be part of it. Really don't know. Some of it is, like I said, just opportunity, why not? If you can get a pretrial evidentiary hearing and get some things on the record, you might get lucky. You might get lucky, find a little concession that sort of hints at maybe the prosecuting attorney already knew he was going to pursue the death penalty before they even really knew what the facts were, really even knew if they were going to have the facts, was already leaning that way. Why? Probably because of who was involved and how high profile it was. Some animals really are more equal than other animals in America, sorry to say. So, just opportunity. It's a death penalty case. There's an argument to be made that even if it's marginal, you really have to do it. And it's frankly better if they do pursue even the really marginal things, because then you just minimize the chance that something is going to go up on appeal and they're going to say it was wrong that you didn't do this, so you got to do it all over again. Really, nobody wants that. So just for purposes of clearing the field of meritorious issues, it makes a lot of sense, particularly in death penalty cases, because they get so much more scrutiny than just regular appeals. They get, automatic review. They get counsel appointed to review the death penalty process. Like, it isn't just that there's going to be an appellate court that looks at it. You're going to have so many lawyers looking at this thing. When I was writing on Substack about the Michael Archuleta case. Now I'm going to forget offhand what the count was, but I think he's had 16 lawyers, something like that. He's had a ton of lawyers that have come on the case. And the thing is that when you're trial counsel, every single one of those lawyers is scrutinizing you, because any tiny mistake that you made is a potential argument for them that you were ineffective and therefore the death penalty needs to go away or there needs to be a new trial or something like that. That's the context that they're in right now. I mentioned they were having this hearing on whether he's got an intellectual disability that was brought to the court through the framework of ineffective assistance of counsel. Did the trial lawyers mess up by not investigating this? And if they had, would they have discovered evidence that would have potentially precluded a death sentence from being imposed? So death penalty cases go through a massive amount of scrutiny. They go through a lot of hands with a lot of people who have very strong motivations to pick apart and second guess every single thing that the defense lawyers do. So you don't want to be the one that was ineffective because you won't get more death penalty cases. You think the next case that comes up, they're going to hire Kathy Nestor if the last one she did got sent back for a retrial because she was ineffective? No. So I think really just clearing the field, given the fact that it's a death penalty case, you raise even the marginal issues just so there's no question about your effectiveness as trial counsel. My personal opinion is probably the biggest reason. But then also, you fish to see what you can get away with. And if you're getting paid in the process, that doesn't really hurt either. 2 Truth for Liberty. Do you know of any state where publicity is among the legitimate aggravating factors for seeking the death penalty? I don't, and I would have a hard time imagining that such a standard would satisfy constitutional scrutiny. And the reason why is because the reason for the death penalty, the kind of Eighth Amendment parameter around the death penalty, it's based on characteristics of the crime and characteristics of the offender. And so it's supposed to be the worst of the worst, meaning either there's something about you that's particularly bad, or there's something about your crime that makes it a lot worse than just, everyday run-of-the-mill murders, as if those aren't bad. Yes, they're bad. But death penalty is about the worst of the worst. Publicity is not only outside of, the person's control, whether or not people get interested about your particular crime or not. But it's so closely tied to First Amendment speech activity, press activity and stuff like that. It just seems difficult for me to imagine how punishing one person more because of other people's exercise of their First Amendment rights could be valid. So no, I'm not aware of one, at least officially. But as far as does that influence these decisions off the books? Of course it does. I mean, how would it not? How would it not? Of course it does. They know people are watching. They know their expectations. They know they're facing re-election in X number of years. And they're going to have to explain potentially their decision. They're going to know what the public sentiment is among their constituents as far as should it be sought or not sought. So, the reality is, of course it does. These are political decisions. Prosecutors are political representatives making discretionary choices. And they're making those choices, at least in small part, based on what is going to maintain their base of public support. So it's incomprehensible to me that publicity would play no role. Somebody would be able to, a prosecutor would make that decision completely divorced from what the press already thinks or is going to think or something like that. They're always thinking about that. But as far as itself providing an independent basis for seeking the death penalty, I don't see how that would withstand constitutional scrutiny. Well, there continue to be filing after filing after filing after filing in this case. A lot of stuff, like we talked about, still outstanding concerning media access. Judge Graf, once again, kind of being our best advocate here. He's going further than even the media is asking for. We didn't get a live stream of the testimony from the prosecutor's daughter, but it wasn't closed. It was available to anybody that was present is going to be able to report on it. Maybe already has. I don't think Brian Enton is there this time because he's down in Arizona following up on Nancy Guthrie. But I'm sure there's reporters from the local area, Salt Lake and so forth, that are going to tell us details about what happened in that hearing. And because it wasn't closed, it wasn't technically closed, there will be a transcript that should be available. So expect we will be able to get a record of that to the extent that that is interesting to anybody to review. But then, Grunander, nope. We know who you are. And so does that kind of blow the witnesses' cover to some extent? Well, it certainly does. I mean, we've been fed enough information that truly dedicated internet sleuths are going to be able to figure out who this person is. But it's enough to be some friction, and so just, I guess, your random crazy who might be looking for somebody to target, it could be potentially more difficult for them to do that if they don't have a name, they don't have a face, they don't have things like that will help them verify who they want to target some vitriol at. So very much a pro public access resolution there. I think all in all it was a little bit less protective than frankly I expected him to be. So with that, guys, December 24th, the next hearing. And in the meantime, keep an eye on the Substack or on the X for the new filings. I am continuing to track those as they come. There's a whole slew over the last week, like I mentioned at the top. So we are getting closer and closer to the preliminary hearing. So it will be interesting to see if issues pick up related to discovery or things like that. We already have one motion that's sealed, so we don't know the specific details, but we know at least it has to do with some kind of destructive testing that the state wants to do, that the defense is looking for. I guess they just don't really agree with it, or they're looking for some kind of ruling from the court on how that testing should be conducted. And the only reason we know that is just because the responses have told us, it implicates the discovery order that they have in place that relates to notice being given of this type of testing and in the process to follow and so forth. We know that the defense has said in their motion that other things like they don't want to bring it up because it involves evidence that might not be admissible, but at the same time they haven't apparently given any basis for it not being admissible. They haven't said objection, here's why it's not admissible. They've just said, well, it might not be at the end of the day. So all a little bit ambiguous. It's just part of the challenge of sorting out what gets litigated behind closed doors and what's not. But so I am interested in how these issues continue to be resolved so that as these motions continue to accumulate, I'm kind of expecting the defense to continue to file stuff under seal. And they're going to have to litigate whether, at the very least, a public version that's redacted is going to be released, or perhaps, in some circumstances, maybe the entire document gets released. I don't know. So we're starting to get a little learning. Everybody is learning how to handle these things. The judge has handled this hearing today with a little bit more organized efficiency. So he may start to do the same with the sealings as well, as we start to see a pattern emerging and just get an idea of kind of what his thought is going to be on legitimate bases for sealing things versus grounds that are not so justified. So stay tuned. Keep your eyes open. Like I said, Substack and X, and I'll keep doing updates on those. Next court date, February the 24th. Guys, appreciate all of you being here. Appreciate your interest in this case. I don't know where y'all are, but it is getting dark here. It's yet another full day in court. that's fine. But the days still are getting longer. It's 5 o'clock and there is still a little bit of light in the sky. So, it's a great sign that things are coming. Those of you who are dealing with ice storms, snowstorms, terrible winter environments, you have my sympathies. I'll share with you my my mild winter, first world problems over here. We've had this incredibly mild winter, just insanely mild by standards of being north of the 46th parallel. I don't think it's gotten below about 20 degrees. And this is a problem for us, guys. It's a problem in a couple ways. One, there's plenty of snow falling in the mountains, but it's not staying there. It's melting and it's running off. And so we've already had flooding, and it's challenging our snowpack. And of course, we out here in the arid West, we are very dependent on our snowpack for our seasonal irrigation come summer. So if there's not enough snow up there, we're going to all have brown lawns, guys. That's bad. But that's not even the worst of our mild winter problems. The worst of our mild winter problems is I went out a couple days ago, end of January, and guys, my apricot tree, the buds are swelling. Okay. It's like getting prepared to bloom. It's getting prepared to bloom. This is really bad. This is really bad. It's super early. We're not supposed to bloom until March is kind of ideal because number one, there's no bugs out yet. So nothing gets pollinated and you don't get any fruit. But then if you start getting fruit at the end of February, highly good chance that a late freeze is going to come take it out. So this is the real tragedy, staring down the barrel of a bad apricot season. Now it's just, I know, up in the north, you don't get a good apricot year every year. And in many ways, I've been blessed with several good apricot years in a row. So it's just, just time to have a bad one. But, you guys that are suffering, you feel bad for me too. I'm just kidding. It's not a struggle at all compared to, people sliding off the roads and, losing power and stuff like that. I am, of course, being facetious, but I do hope everybody is well and that, winter isn't treating you guys too badly. Summer, of course, down in South America, down where, I think of back a year ago today, I was down on Navarino Island, down there, right near Antarctica. Very, very different situation. They're having major fires in Patagonia this year. So it is, of course, summer right now and making it perhaps not so pleasant to be in some of those beautiful areas. So any of my Chilenos down there, any of my folks down there in the beautiful lands, I hope that you are breathing freely and that those fires get under control soon. So with that, guys, I'm going to check out. It's time to put the chickens to bed and see what these cats have done to my house while I wasn't paying attention. I wish all of you the best evening. I'll see you guys soon. Take care, everybody.